in this matter. I am the award holder. Section 36 has been filed against me. There is a section 34 also. And I have filed, after filing section 36, they have, my lord, the award debtor has, my lord, secured a portion of the claim. Now, I have filed an application before this honorable court, my lord, for withdrawal of that amount by giving a separate security. That application is pending. There is a direction for reply, filing opposition.
You are mentioning that application?
No, I am not mentioning. What difficulty I am facing, my lord, during the pendency of this company went to liquidation and a liquidator has been appointed. There was a change of office. So all the old papers have misplaced. Now I am not been able to get hold of statement of claims, counter.
So what do you want now?
My lord, I have written to my other side twice, thrice. They have not provided us with the copy. I have, my lord, requested the honorable arbitrator for certified copies. Honorable arbitrator has informed us until and unless there is an order by your lordship, by the arbitration court.
Just right to be mentioned and
yes,
give a notice to the other side, right?
Yes, I have mentioned on notice. Only a direction, my lord, I can be given.
Remind me when it is taken up, it will appear as to be mentioned. Yes.
My lord, may I be permitted to mention one matter? The settlement amount reached was 4 lakhs. But the judgment debtor has to pay more 80,000 approximately.
What do you want to, you want to
inclusion in the
inclusion of what?
For,
an application under?
Inclusion, my lord.
Inclusion of an application for inclusion.
EC.
EC handover, EC. Yes.
Kindly to mention 2 matters, Lord. One, execution of a foreign award. All parties are here. This was a hotly contested matter. There's a claim of about 200.
Hotly contested, refused.
Appearing for the first time. My EC. If that could appear on the 9th, along with my, because I've taken consent, Mr. Mitro, the other side, there are several other people. There's section 9, which is complete now pleadings. If that could also appear along with it.
Well, give this. 9th, it is 9th.
I am opposed to both being heard together. Execution is different and 9 is different. We can take it.
Let them appear together to satisfy me on that. Yes.
Mention it together.
Because otherwise there will be a mini hearing now. Otherwise. Yes. Yes. You from that side now. Be a bit louder. Execution, yes, handover.
There was an order for the judgment debtors to make a payment of 1.3 lakhs in June and then in July.
You are asking for inclusion of the yes, handover.
For application, my lord, 1%.
Connected.
Yes, connected.
Yes.
That's right. One more, my lord.
Your quota is over for today. Come back tomorrow. Yes.
For withdrawal, my lord.
Withdrawal, absolutely. Yes. Oh, you kept it last. Yes, Mr. Shah.
My lord, slightly strange circumstance. I am, my lord, seeking your lordship's kind leave to, my lord, file a section 34 application seeking setting aside of an interim award or part award. My lord, the department is refusing to take this on file. So I'm only seeking.
Why is it not maintainable otherwise?
My lord, I can satisfy your lordship that it is maintainable. My lord,
yes.
Indian Farm Fertilizers versus
So on what ground are they refusing?
My lord, because the arbitral reference is not finally terminated by the passing of this award. So, my lord, they are.
You say a part award has been passed.
Yes, partial award or interim
award. Leave is granted. Leave is granted.
May I have my lord's kind leave?
No, I'll complete this side, yes.
May I have my lord's kind leave to mention a matter? My lord had taken up this matter last Friday and recorded settlement between both parties and disposed of the EC and 2 APs, my lord, 2 section 34s. One of the directions passed was, my lord, for the cash security deposited with the original side, my lord, to be released to the award holder. Now, my lord, we have written to the registrar original side. They have said that they need the account number of the award holder to be indicated in some form. So, my lord, if the matter could be...
It will appear as to be mentioned.
Very well.
In from the other side.
Lord,
yes, Mr. Bhatt.
Grateful.
My lord, wait for your lordship's kind leave to file an execution. My lord, the original award was lost. A 34 was filed by the judgment debtor.
Yes.
My lord, we have a copy of it and that has been certified by the department.
And leave is granted. Yes.
May we permitted to mention one section 34 application?
Section?
34 application.
Yes.
May we permit to mention
from that side again? Yes. Handover, yes.
Lord, may we permitted
yes, you. Withdrawal handover, yes.
My lord, I am praying for inclusion of a matter. It is under section 34 of Arbitration and Conciliation Act.
For so many matters I'm adding already. Anyway, why should you be deprived? Yes.
May I permit to mention an execution application for inclusion?
Handover, yes.
My lordship may perform.
Use the mic. You have the mic before you. Yes.
My lordship may permit me to mention a matter of one appellate side.
Appellate side, no, not now. I'll take up appellate side on Friday. Mention then.
Your lordship, a matter to be mentioned for.
What is this?
Your lordship,
on 8th May 20.
So what is the application? Is it an application or a?
It is, Your Lordship, CP.
You are there. What is this?
The application, my client's property may be, there is a direction of this honorable court to steer.
So what application? I can just use a mic.
The application, my lord.
Say, yes, hand over.
Direction with the CP. Get put upon
Call the
notice.
list now. Yes.
Item number 1 to be mentioned.
Award holder, my lord.
Yes.
The pleading to be mentioned, I know, because in this matter on 1st July, my lord directed this matter will appear on 15 July. When in this matter, the amendment has been allowed. The name of the award holder has been changed. Only the reaffirmation is pending. I am praying let it appear on returnable date on 15 July, directed by on 1st July 2024.
Yes.
I'm only praying my direction should be given department to complete the reaffirmation of
That direction is already there.
direction is there, my lord, on last occasion, but that time has expired, my lord. On 15 May, it was directed A and C. Department has taken step. Name has been changed.
When
My affirmation is that last.
no, I directed the department to do it within limited time.
Yes, my lord. There is an order passed by in terms of prayer A and C.
What is the date of the order?
Date of the order 15th May 2024. That is passed in GA 1 of 2024. Everything has been completed. Only the reaffirmation is pending. The award holder has.
So you want a direction for that reaffirmation to be done within a limited period?
Within the returnable date, that is the 15th July
15th July.
2024.
Yes. So what? Today we are on 3rd of.
Yes, but that direction they require in the order dated 1st July 2024, my lord.
That is not there.
That is not there. Please see the order of 1st July. Only the matter has been adjourned till 15th July. Only I am saying only one sentence to be added. The department directed to complete the reaffirmation of the.
Very well. On the prayer of learned counsel for the petitioner, the department is directed to reaffirm the affidavit after the substitution was after the substitution is carried out. Within 15 July, within July 15, 2024.
Yes.
যা বললাম তারপর within 15. Yeah. Next.
Item number 2, State of West Bengal.
যা আছে বাকিটা আছে।
Your lordship, beg to appear on behalf of the petitioner state, your lordship. On 1st July, this matter had appeared, wherein had indicated that talks of settlement are going on.
Yes, sir.
And
Right.
there was a communication to that effect to the respondent as well. So I understand it will take some time. The time limit has been given.
Yes,
So it has to be, they have to respond by 25th July, I understand.
So should I keep it in the monthly list of September?
I think that would be.
September monthly list. Very well. Learned counsel for the parties submit that the negotiations are at an advanced stage for the purpose of settlement and seek some time for the said process to be concluded. Full stop. Accordingly, on the prayer of the parties, let the matter be listed in the monthly list of September 2024 under the same heading. It will appear under the same heading. If the settlement fails, then
I think there is only one matter is appearing today, but there are 2 matters on the list.
when they appear, then
Both of them.
no, those are not appearing. I'm not passing any order on those.
No. The analogous matter is not analogous. The connected matter is AP Com 40 of 2024. That is the 34. Today we are, what is appearing?
Is it appearing today?
No, that is not
I'll
appearing.
not pass any order in that. If something is not appearing in the list, I make it a point not to pass any order in that. That creates complications. That has previously, our history says that has created many complications. Same matter, 4 orders passed during the same day. I don't want to go into this. When it is appearing in the list, I'll pass.
Oh, check.
Yes, next.
Item number 3, Mukhtar Alam versus Yasmin Khalik.
Lordship, this is my petition. Not very clear why this has come as to be mentioned, my lord.
কি জন্য
Perhaps,
তুমি-
my lord, because we had filed it or tried to file it before the non-commercial division, my lord, it is
order sheet টা আছে কি জন্য তুমি mention লেখা আছে mention
May I request your lordship to keep it at your lordship's earliest convenience, my lord, in this matter.
It is wrongly appearing under this heading. It will appear under the regular heading. To be mentioned, nobody mentioned. The matter is wrongly appearing under the heading to be mentioned. Push up. Let the same be placed tomorrow under the regular heading.
Great.
Thank
My lord, instead of tomorrow,
I was going to make the humble request that tomorrow and day after I'm in difficulty. This matter will be pursued.
Mr. Shah, please use the microphone.
My lord, tomorrow and day after, my lord, kindly excuse me, kindly keep it, my lord, any day after, my lord.
তাহলে
this-
tomorrow না করে
After the 5th, anytime after the 5th.
on July 8, 2024.
I'm very grateful.
Under
Very, very. ঠিক আছে।
corrected.
Item number 4,
This is my application for withdrawal of the money deposited, my lord. My lord, here affidavits have been completed. May I file my affidavit
Please.
reply, my lord?
Yes.
Any date may be fixed, my lord. Next week, any date, my lord.
Section 34.
My lord, this is
No,
the application for withdrawal of the
No,
money.
no, this I'll allow right now.
The application.
Yes.
You can-
My lord, we are opposing the application.
my lord, there are
So
judgments.
very well, I'll keep the application then. Next week, you say.
Anytime next week, my lord.
Let the application bearing GA number 3 of 2023 be placed under the appropriate heading in the list of July 8, 2024, next Monday.
Oh, no.
To be mentioned আসছে কেন? To be mentioned বলেই করেছে mention. আরেকটা লাইন অ্যাড করে নিও যেটা বললাম affidavit reply filed to be kept on record. Next. Service. Reply affidavit of service. What have you filed today? Affidavit of service. You said reply.
I'll file. No, my mistake.
পরের দিন করে দেবেন, সোমবার করে দেবেন।
File it when it is taken up.
Affidavit.
Mr. Gupta, you endorse it. It's a-
No, no, I am opposing.
No, I know. That's you said
It is opposing the filing of service.
opposition has not been filed.
Opposition has been filed. This is the reply they're filing.
Opposition has been filed or just given a copy. Check up. Otherwise,
চেক ফাইল করেছো, তোমার আছে কি না? So we were also not.
আছে next day. ওটা কেটে দাও. Next.
item number 5,
Your Lordship, I appear on behalf of the respondent award holder.
ফাইলটা দেখি
Upon mentioning the matter on Monday, Lordship had directed to list the matter to be mentioned since the award under challenge has been passed by former Justice Bhaskar Bhattacharya
আচ্ছা
for release.
আচ্ছা this is a section 34.
Yes, yes, Your Lordship.
Since the award under challenge was passed by one of my relatives, comma, let the matter stand released from my list on personal grounds, with liberty to the parties to seek an assignment before a different bench. Full stop. The file be sent to the Honorable the Chief Justice for such purpose at the earliest.
I was for the petition.
Pardon?
I am for the petition.
Petition, yes.
item number 6, Mrs. VK Patel and Company.
Lord, first of all, my apologies. Yesterday I could not be present in matter.
No, no, no
passed over.
difficult.
I was
Yes.
stuck in another courtroom.
Yes. Oh, that has, yes.
Well, 2 points taken by the friend in this matter. Number one, that I have consented to the payment terms by an order, and therefore I have to accept that the payment has to be as per those rates, as per one rate, which is on the appointed date. And secondly, a legal point, rate has to be of the appointed date and not a fluctuating rate, or not a rate which is as and when it stands, my lord. So, my lord, as far as the first point is concerned, my lord, I have, my lord, judgment established principle of law, my lord.
Yeah, sorry, please continue. Yes.
My lord, there is no estoppel against law. If the law prescribes a rate to be of a particular type, just because I have said that I will pay it at a particular manner, it doesn't make that I have to do it in that manner, my lord. If your lordship takes the order by which, my lord, Justice Saraf's order, which, my lord, they had, my lord, here what had happened, my lord, they filed an application and then they filed a supplementary affidavit. In the supplementary affidavit, they have taken a paragraph 6 where they have where they have stated the rates at which it should be paid, the rate rather. Well, the supplementary affidavit, paragraph 4, page 4, paragraph 6. Yes. The three rates are given of three different bills, rate at one rate of the appointed date. They have taken into 3 times. And in the order, my lord, the order records that, yes, my lord, the order records respondent is agreeable to payment as per paragraph 6.
That order is dated?
That order is dated 10th April 2023. So my learned friend,
is agreeable to.
Yes, my learned friend has taken the point that since I have said that I am agreeable to payment as per paragraph 6, therefore now I have no other option. I have waived my right. But Mala, there is no estoppel against law. Law prescribes a rate to be of a particular type. Just because I have made a statement in an order doesn't mean I'm bound by it. Mala, there are judgments. I have got all the judgments.
No estoppel against law.
No estoppel against law. I have got the judgments with me as recent as 2022 Supreme Court also. Mala. If your lordship wants,
is there any contrary judgment that there can be estoppel against law?
No,
if there is any, please cite that, Mr. Mukherjee. It will be very useful for me.
Well, your lordship knows it can't be like that.
Everybody here knows.
Yes. But also, a statement made by a counsel, any other admission also, if it is
no, for the sake of completion, Mr. Mukherjee, you can cite because you are ready with the judgment. Cite the most important or 1 or 2 landmark judgments. Not too many on this point at least. এটা কি? এটা ছিল আগে?
Will give me 1 moment. I have marked on my iPad. Well, 2022, volume 8, SCC 713. This is the latest judgment.
Yes.
Para 23 to para 27 on. My lord, all the other judgments have been.
Yes, that is
summarized, my lord.
This is an advocate's concession.
My lord,
or generally,
generally a concession. It's records, my lord.
Yes.
Settled principle that. I will just read it out, my lord. The paragraph which I'm relying upon. Statement, assurance, or even undertaking of any officer or a counsel of a respondent or a government pleader or of the state is irrelevant. Malad, the statement is irrelevant till such time malad, that the law says something else. Malad. So malad, on those, malad, I'm not malad, repeating on all the judgments. Malad, this judgment records all that. Now, malad, if your lordship takes malad, the section once, and there are recent judgments of Calcutta High Court also, which I have found, with regard to how section 16 has been interpreted. Malad, what is the law? What is the law, Malad, if your lordship takes section 16 again, Malad? Your lordship, it has been read out a few times, but just for one last time, Malad, your lordship takes. Where any buyer fails to make payment of the amount to the supplier as required under section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any law for the time being in force, be liable to pay compound interest with monthly rests to the supplier on that amount from the time the appointed day, or as the case may be, from the date immediately following the date agreed upon, at 3 times of the bank rate notified by Reserve Bank. It does not say at the end at 3 times of the bank rate notified by the Reserve Bank on the appointed date. It does not say that. There is no dispute that it has to be from the appointed date, the rate and the payment due has to be calculated from the appointed date or the date agreed upon. In this case, the arbitrator has held it is from the appointed date. The facilitation council who's been acting as the arbitrator. They have not given, they have said also in the order, in the award rather, that it will be as per section 16. But they have not given a calculation.
So rate is not fixed to the appointed date.
The rate on appointed date nowhere mentioned. It is from the appointed date that it will be paid. Well, if your lordship for once takes the award, because I feel the arbitrator should have gone on further.
It stays only as per section 16.
It reads, yes, it reads out with interest on each and every due amount payable as per section 16 till the realization date. That one paragraph, nothing else. But
Each and every date refers to the 3 bills, the separate bills.
3 separate bills.
Right.
There's no dispute about that. I have not made payment of the 3 bills on time. There are delays. I'm not disputing.
No.
Only issue is whether it will be one rate of the appointed date or fluctuating rates as and when RBI is notified. Well, there are 2 judgments of this court. Lord, 22 SCC online, Calcutta 3342. My Lord, it's your lordship's friends' judgments only, my lord, which are there. Your lordship last time told me. But
Yes.
they were the ones who were sitting on this
Right,
bench before, my lord.
No.
My lord, the issue here was with regard to, my lord, if the arbitrator, these are all 34s or 36, taking the point, my lord, that if the arbitrator, the facilitation council has not decided of how the interest will be, whether the award is good or bad, on that issue. My lord, if your lordship takes 2 paragraphs in this judgment. My lord, paragraph 19. Well, the rest of it also goes on this point only. The fact that the facilitation council acting as an arbitrator passed an arbitral award without making any effort to quantify the interest claimed or even the date from which that interest will apply is incomprehensible to reasoned mind. The award due to the very reason falls within the contours of unreasonable award as has been laid down by the Supreme Court in many awards. Furthermore, as discussed in para 14, the delegation done by the council is flagrantly in violation of the principles.
Here the date was also left.
Date was also left. They did not decide. I have not filed a 34. That is my.
No, and here the date has been given by as per section 16.
But my lord,
that is acceptable.
The interest also has to be calculated.
Right.
Lordship now takes para 14.
Yes.
Where Supreme Court, my lord. Then, my lord, paragraph 15. The principle is a testament to the very fundamental concepts on which law of arbitration stands. If the parties in the present matter have placed their trust in the court to arrive at the judgment, this cannot just hand over its responsibilities to anyone else and ask them to make the judgment. In this case, my lord, in the matter in hand, my lord.
But these judges do not help you, Mr.
Saying that the arbitrator should have gone one
Should have, but
further.
that does not help
They've
you
not
because you have not taken out a section 34.
On this
is
basis,
besides the point.
My lord, only reason I was showing this because further from this judgment, my lord, taking forward from this judgment, taking cue, my lord, Justice Bhattacharya, when she was here, she passed a judgment where she has held that it is fluctuating rates.
That is actually apt.
Absolutely,
Because this is
follows from this.
This would be appropriate in a challenge under.
If I had also filed a section 47, it would have helped me.
Happy, tribunal happy.
Section 47 is
dangerous.
Now on very dangerous footing.
Yes, my lord.
Yes. This judgment was relied on by Justice Bhattacharya.
Yes, my lord.
And where is the relevant paragraph which says fluctuating?
My lord. My lord, paragraph 32. Section 16 of the MSME Act thus an onerous responsibility on the council to fix the rate of interest and also the time period for which it is to be paid. The council must also determine the relevant bank rate as notified by RBI at the relevant point of time together with any fluctuations spanning the period. The last determination is significant since the interest under section 16 of the Act is to be at 3 times of the bank rate. The contention made on behalf of the award debtor that there were revisions in RBI rate from June 2015 to September 2019 becomes relevant. The council should have taken this issue into consideration and adjudicated on the specific rate of interest on multiple planks of section 16 of the Act instead of shifting the responsibility of adjudicating to a chartered accountant. This was one of the section 36 application filed, where the issue was what will be the deposit amount, the 75%, whether it will be principal and interest or just the principal. Because the arbitrator did not decide on the interest rightly, so the court held 75% will only be on the principal. And why was the principal not decided rightly? One, it was delegated to a chartered accountant. And two, the chartered accountant gave one rate. The arbitrator was duty bound to decide on what will be the appointed date plus the rates which will be applicable.
Those principles do not help you, Mr. Mukherjee. Only fluctuating rate, this sentence helps you. In this matter, because however much we may criticize the order of the award of the arbitrator, we cannot go into that.
Now, Malat, and I have also, Malat, I have some literature, but I don't want to show literature as in, Malat, there are articles in various websites where which show that it will bank rate from time to time.
No, regarding section 16.
Section 16. Bank rate will be
articles by which
articles by websites, how it is to be calculated. I was looking for
don't rely on that. That is not authentic.
But that is the practice which is followed. So it is bank rate from time to time. Otherwise, Malat, the section it is a penal section, Malat. It has to be interpreted strictly.
Yes.
Section 16 does not go on to say rate as of appointed date. Malat, and Malat, my learned friend Malat had said that I am benefiting out of it. It is not benefiting. I do not know.
Mr. Mukherjee, here strict principle, comes in later on. Strict principle, undoubtedly penal provision, strict principle. But where there is an ambiguity in the section, then it has to be subject to purposive interpretation or whatever. Satisfy me that it should be in favor of the award debtor.
It's not about favor of the award debtor or anyone.
If it's not beneficial to the award debtor, it cannot be beneficial to the award debtor. Strict interpretation because it's penal.
It's penal, and I am.
That is the only leeway you can get. It has to be a strict interpretation. But how do I strictly interpret as a provision?
Because
on that date it is not there.
On that date is not there. Had that on that date been there, my learned friend's interpretation would have been correct. And Malad, if we go by what the section reads by itself, Malad, bank rate notified by RBI. Notification is from time to time. And there is as Justice Bhattacharya Malad has said, Malad, at different times, there are different tranches.
Yes, that sentence only helps you in that.
Multiple planks, different tranches.
Just go back.
And Malad, in this case, there have been around 8 or 9 tranches, Malad. The rates have changed. If your lordship sees
the multiple planks, that was in the same paragraph.
Same paragraph, para 32.
Yes. Sorry.
And this is absolutely apt on the point also, because the issue was this issue has been decided. The court has held.
No, multiple planks of section 16 is different. That does not mean multiple.
Well, if your lordship reads, the council must determine the relevant bank rate as notified by RBI at the relevant point of time together with any fluctuations.
This squarely applies to your case and is in your favor.
But also the next paragraph, the contention made on behalf of the award debtor that there were revisions in the RBI rate from June 2015 to September 2019 becomes relevant.
This paragraph is squarely yes.
And then, Malad, now if your lordship reads the next paragraph, that is what multiple planks means. The council should have taken this on multiple planks of section 16, as in, Malad, the different RBI different planks, Malad, the different rates. I feel that is
the first 2 sentences are there in any way. Yes.
And Malad, now if your lordship sees the way the calculations we have done, Malad, both parties have filed their calculations. If your lordship sees the notes of argument which have been filed by my learned friend, that has my calculations also. I am not going on any other thing, my lord, only on that is fluctuation rate.
Yes, yes.
My lord, if your lordship sees my learned friend's rates, my lord, it starts at page 4 of the notes of argument. The way my learned friend has made the calculations. Page 4 is the summary. If your lordship comes to page 5, rate notified by RBI 6.25. I have no doubt about that as on the appointed date, rate was 6.25.
So this is entirely on the premise of appointed fixed rate.
Now, if your lordship sees my calculation, which is page 12 onwards, page 11 is the summary, and page 12, RBI notified rate was 6.25, no dispute as on the appointed date. But it has changed over time, my lord. My lord, the 1, 2, 3, 4, 5,
No, here we have to decide the principle.
Only
which is
the
applicable.
principle.
If the principle,
Of the
your
calculation
principle is
is-
accepted, then this
That
applies.
is all. These are my submissions. And my lord, I'm not stopped just because I have made that statement in that paragraph, my lord. Because the law is something else altogether. And I have done the calculation as per law. I'm obliged, my lord.
Close arguments.
I'm led by Mr. Chaudhary Banerjee. My lord, he will just rely upon one more interest charge and this close the
One more?
interest chart, my lord, to
Another?
further explain.
No, after the hearing is over, the
I'm not-
arguments are concluded.
I'm not, my lord, arguing on the only on the method, on what will be the rate. No
That
other
will be
point I've
decided
argued,
on.
that's all.
I may also decide the principle and direct the arbitrator to only adjudicate on that.
I think that is what that should have
The
happened.
chart should be placed before the arbitrator for that limited time. I'll fix a time and I may do that. I mean, instead of doing it myself, which will deprive both of you of a forum. I mean, your calculations have to be done by the arbitrator. So I'll just decide the principle which applies after. Hearing is concluded. Judgment is reserved in the matter. এটা একটু পাঠিয়ে দিও সব শুদ্ধ থ্যাংক ইউ মিস্টার
New motions, section 11, item number 7.
My lord, I appear for the petitioner, my lord.
Yes.
The respondent number 1.
Please take the mic a bit lower.
My lord, disputes arise out of a contract by which, my lord, my client was required to, my lord, construct a B plus G plus 7-story building for South Damdam municipality at Jasso Road. My lord, I had, my lord, in terms of the contract, executed the work, raised bills, my lord. Last, my lord, RA bill was 10th RA bill. There were, my lord, certain works which were directed to be carried out subsequently. And finally, my lord, I was asked to revise and file a final bill, which was, my lord, the RA 11th bill with the final bill. And I had submitted that. My lord, thereafter, my lord, since I was registered under the MSME, my lord, when they were not paying my bills, my lord, I went up to the council with a, my lord, prayer for conciliation. My lord, the conciliation failed. And thereafter, my lord, the stage of 18.3 came where arbitration, my lord. There, my lord, the tribunal council felt that since at the time when the contract was executed and, my lord, when I was performing, that registration certificate was not of that date and it was of a subsequent date, I would not be entitled to, my lord, proceed with my claim before that council. So there is an order giving me liberty to pursue my claim before an appropriate civil
I don't
court.
understand this last question. Why not before that council?
My lord, because, my lord, the certificate of registration, my lord, to be entitled to be, my lord, invoke the jurisdiction of MSME council, my lord, the law as it stands today is that you have to got a certificate prior to getting the contract. So you cannot, my lord, after getting a contract, part performance, and then you get a
Also,
certificate so as to go to council.
Goes
That
outside the domain
yes.
of.
So, my lord,
So conciliation, I mean,
it was, my lord,
even
properly not
in
advised.
any event, conciliation also.
Conciliation was also, my lord, it had failed, and arbitration, the tribal council's order is there.
So then you
giving
gave
me
a section
liberty.
21.
Then I gave a section 21 from that date, and, my lord, I have come.
Where is the arbitration clause? Just show me that.
My lord, kindly comes to, my lord, page 50, clause 24, my lord.
Great.
And, my lord, termination, lordship will find of the conciliation proceeding at 134.
No.
My lord, page 1. Yes.
134 is not termination. Or termination.
135 is the, my lord, order.
Yes. Right.
That is the minute of 16 December 2022. My lord, will kindly come to the foot of that page, decision of the council. Members of the council opined that initially matter was taken up for consideration in view of beneficial object of the act and tried to give relief to the distressed supplier unit under the relevant provisions. But during today's hearing, representative by unit raised a point of maintainability owing to non-possession of MSME registration certificate by supplier unit at the time of entering into the contract of supply. My lord, it is for this reason, my lord, that and the Supreme Court decision was considered, it was done. My lord, thereafter, my lord, if your lordship comes to my lord, my 21 notice at page 137. My lord, we briefly describe what is my lord dispute and how the claim arises. If your lordship now comes to page 140. My lord, this is my claim amount, 1 crore 10 lakhs and odd. And I had nominated a name, but since now, my lord, parties have not agreed, lordship may appoint any independent person, unless my learned friend says she
Yes,
has.
what do you say?
Your lordship may appoint.
Mr. Abhishek Guha would have been best because he's the banker of the High Court.
But since I have
Banker
nominated
of the
him, my
bar.
lord, possibly, my lord, in a section, I leave it to your lordship.
No, he should not be. I mean, because you.
My lord, I also felt so, my lord, because I had nominated, my lord, that's the reason. Independent person, anybody from the member of the bar can be appointed.
Suggest a name, both of you. Yes, Mr. Dotto, any other banker among the bar members? What's her full name? What is your full name? The lady, yes. Pardon?
Anuradha Poddar.
Poddar.
Lordship,
I'll appoint her.
yes.
She has a financial brain. Upon hearing learned counsel for the parties, it transpires that the matter went to the MSME Council under the MSME, under the Micro, Small and Medium Enterprises Development Act, 2006. Initially, after conciliation failed, the matter was sought to be taken up for arbitration, at which juncture the MSME Council found that the same fell FELL outside the PALE of the said statute. Next para. Accordingly, the petitioner issued a notice under section 21 of the Arbitration and Conciliation Act 1996, thereby invoking clause 24, which is the arbitration clause in the agreement between the parties. Having the parties having arrived at no consensus, the present application has been filed. Next para. I find from the arbitration clause that the same fully covers the dispute raised between the parties and the matter is in principle arbitrable otherwise. Next para. Accordingly, AP Com 606 of 2024 is allowed, thereby appointing Ms. Anuradha Poddar, you are a member of the Bar Library Club or the ILS?
Bar Association, my lord.
A member of the Bar Association as the sole arbitrator to resolve the dispute between the parties, subject to obtaining a declaration from the learned arbitrator under section 12 of the 1996 Act. The remuneration of the arbitrator shall be fixed by the learned arbitrator in consonance with the provisions of the 1996 Act read with its schedules.
My lord, respondent number 2, my lord, despite service chose not to appear, though my principal claim is against SDDM, which is respondent number 1.
Service has been affected.
Yes, my lord.
First paragraph, affidavit on record, stop.
It shows item delivered, my lord.
Despite service, the respondent number 2 does not appear, although the other respondent is represented through counsel.
One submission, my lord, the remuneration will be, my lord, paid in equal share. There are 3 parties, my lord.
Still decide it. Mention before the arbitrator.
Grateful, my lord. My lord, I filed the affidavit of service.
First sentence.
Oh,
yes.
Sorry.
Item number 8.
Yes.
AK Logistics Private Limited.
Well, this is my application, my lord.
Section 11, you're opposing.
To oppose
Technically opposing.
8, 9, and 10, my lord. I'll just indicate the dispute, my lord. There's an arbitration clause. There's nothing much in it, my lord. It's a dispute concerning a work that my client has done in respect of 3 power stations, thermal power stations of the DVC. There were work orders issued in 2019. There was separate contracts for each power station executed by and between the parties on separate days. That is why
the arbitration clause.
Yes. my lord has AP 631, that is the first item.
Yes.
My lord will kindly directly come to page 49.
How many items are there?
There are three. There are three separate contracts for three separate power stations. That is the only reason.
But the parties are the same.
Parties are the same. The dispute is
So
also
the
very
same
similar.
person should be appointed as
My lord,
arbiter.
that would be a humble prayer, my lord.
Right.
My lord will kindly come to page 49 directly. Page 49, clause 17, my lord will see. It's an omnibus arbitration clause. There's no accepted matter per se. The only issue in the arbitration clause is that it provides that the chairman of the DVC will appoint unilateral appointment. That is no longer good law. Therefore, my lord, I have issued a section 21 notice and a request for reference to arbitration. That is at page, my lord will kindly give it. That's on 29th March 2024 at page 66.
Right.
My lord, in between there are several correspondents where I have raised dispute because I haven't been paid the full amount for the work I've done. That is the dispute. Page 66 is my.
So what is the quantum in dispute?
Here, my lord will see from the section 21 itself 20 lakhs in this case. The other case, there are two other cases. There's 40 lakhs and 70 lakhs.
Very well. Appoint Ms. Noel Banerjee.
My
as
lord,
the
I do
arbiter.
not.
Very well done.
Is she connected in any way in this matter?
Don't believe so, my lord.
No. If you're unsure, then I won't appoint her.
He had a proposal if it commences to my lord, Mr.
Tell me.
Vishwanath Chatterjee, so member of the Bar Library.
Yes,
Club.
Vishwanath Chatterjee, I know.
We discussed it
If you
also.
don't have any difficulty, then I'll appoint Vishwanath.
We had discussed this with my learned.
Yes, definitely. Why not? Mr. Vishwanath Chatterjee is quite competent.
Right.
8, 9, 10.
Separate
orders. Copy paste হবে কিন্তু separate orders. Last year AP number টা change. Arising out of different contracts. But clause is same.
The clause is exactly the same because
Clause number is also same.
Clause number is also the same. I believe. My lord, I'll just check.
Very,
The clauses are exactly identical. whether
very
the
well.
number
I
is
won't give the clause number.
17.
Upon hearing learned counsel for the parties, it transpires that a dispute has arisen between the parties which is squarely covered by the arbitration clause
Yes,
in the agreement between the parties, embodied in clause 17.
Clause 17, all
In clause 17 of the contract, which contemplates any dispute within bracket S or difference within bracket S arising out of or in connection with the agreement stroke contract to be referred to arbitrator after being attempted to be settled amicably. Whose sub next para, in the present case, amicable settlement has failed and the petitioner issued a notice under section 21 of the Arbitration and Conciliation Act 1996, thus invoking the said arbitration clause. Full stop. Next para, it is to be noted that the arbitration clause also mentions an employee, that is the chairman, the CEO of the DVC stroke respondent as the proposed arbitrator. Full stop. However, in view of the provisions of the amended 1996 Act, the employee of the DVC, having direct interest in the matter, is disentitled from acting as an arbitrator. Full stop. As such, since the matter is otherwise, since the dispute is otherwise arbitrable, AP Com 631 of 2024 is allowed, thereby appointing Mr. Vishwanath Chatterjee, a member of the Bar Library Club, as the sole arbitrator to resolve the dispute between the parties, subject to a disclosure being obtained from the learned arbitrator under section 12 of the Arbitration and Conciliation Act 1996. Stop. The learned arbitrator shall fix his own remuneration in terms of the provisions of the 1996 Act and its schedules. Thank you.
My lord, affidavit of service may be kept.
Affidavit of service.
Deeply obliged.
হ্যাঁ সেম অর্ডার তিনটে হবে শুধু এপি নাম্বারটা ডিফারেন্স যেটা
Item number 11.
My lord, in item number 11, I am for the respondent, my lord. My lord, there are some facts which are corroborated in the sections 11 application, my lords, are required to be distinguished, and some facts are required to be included, my lord. For that reason, my lord, I
see. Does it have any direct bearing? If it has a direct bearing, then definitely I'll give you.
Direct bearing, my lord. Why I am saying, my lord?
Tell me, just indicate. Otherwise, I can record that you are denying all the facts. That I can record. But why?
First thing, my lord, the terms and conditions which has been laid down and stipulated in the development agreement, my lord, are seriously violated by the petitioner itself, first thing. And second thing, my lord, a title suit was also filed in regard of the same cause of action.
Definitely, I'll direct you to file it. How soon can you file that? How soon can you file your affidavit?
My lord, within 2 weeks, my lord.
2 week, 1 week, then there. On the prayer of the learned, counsel for the respondent, comma, since certain disputed facts are involved in the matter, comma, the respondent is directed to file his affidavit in opposition within a fortnight from date, full stop. Reply, if any, shall be filed by a week thereafter, full stop. The matter shall be listed for hearing on July 29, 2024 under the appropriate heading.
Great,
thank
Not affidavit of service.
Oh, yeah, affidavit of service filed today.
New motion, section 29A, item number 12.
Lordship, I am appearing on behalf of the petitioner. Lordship, it's a change brief. I have not received the NOC from the erstwhile advocate.
When should
I
I
need
keep it?
2 weeks time to.
On the prayer of the petitioner, let the matter stand adjourned till July 22, 2024.
Grateful, Lordship.
2.5. Yes. 22. Next.
New motion, section 34, item number 13. With item number 14.
Yes.
Lord, kindly takes volume 1 once.
Page?
Volume 1.
Volume.
Page.
That figurative matter on the figures
Yes,
center.
ma'am.
Yes.
Volume 1, page 52.
Volume 1 of the GA.
No,
The
my
main.
AP 464 of
Yes.
minute.
Volume 1, page.
Page 52. 48, my lord, the statement of claim starts. My lord, yesterday I had indicated that there is their case, my lord, that the work was completed. My lord, the page 52 talks about the schedule which admittedly they have given from the contract.
Yes.
The schedule of release of the security deposit. And my lord will kindly see page 55. Paragraph 9. The fifth line, my lord, in this regard, the claimant states that the tender work was completed by the claimant on 24th September 2010. So the maintenance period continued up to 23rd September 2030. So, my lord, it is their case that the work was completed on 24th September 2010. My lord, I had shown the work order when, my lord, the cause of action starts, my lord, from the completion of 1 year for the first tranche. So, my lord, my submission was that the learned arbitrator had held that the termination of the contract was, according to the learned arbitrator, on 1st March 2011. From there, my lord, the defect liability periods was of 3 years. So, my lord, 2014, my lord, the cause of action ends. The cause of action starts, and my lord, it ends in 2017. And my lord, the 21 notice was issued on December 2016. So, my lord, for that, my lord, I had relied upon a judgment yesterday, my lord, the Delhi Rail judgment which I had relied upon. My lord, may I also rely upon one judgment, 2022 4 SCC 463. My lord, paragraph 43, only on the principle. Page 485.
Yes, para 43.
That an arbitral tribunal, being a creature of contract, is bound to act in terms of the contract under which it is constituted. An award can be said to be patently illegal where the arbitral tribunal has failed to act in terms of the contract or has ignored the specific terms of a contract. So, my lord, on the ground of patent illegality, my lord, yesterday I had shown a judgment and my lord, I want to rely on.
So the contract provided the starting point to be that, and
Yes, my lord. How the security deposit would be released, that was provided in the contract itself. And also, my lord, yesterday I had shown that perversity on the calculation on the point that
second limb, second
yes, my lord,
figure.
the second figure was increased,
Yeah.
but the third figure was not increased. And my lord, I had also shown the page, my lord, 713 of the volume.
So they please put in a very brief written notes of arbitration.
Yes, yes.
Just put in these points, bullet points will do.
Yes, ma'am.
And refer to the.
For that, my lord, also that Delhi Rail judgment will be applicable, my lord, where it says that, my lord, it is so perverse or so irrational. My lord, by logical conclusion, that had to be changed. The third figure. My lord, that Delhi
Yes,
Railway
perverse irrational. Right.
Yes, my lord. So, on the face of it, my lord, that should not have been allowed, my lord, because it is the calculation of the learned arbitrator itself. It is not something that we had indicated in our written notes.
Nothing else is to be looked into.
Yes, my lord. By logical conclusion, if the second figure increases, the third figure also. My lord,
The ground for that was section 33 was not filed by you, probably.
My lord, 33 was filed by them.
The ground for
Yes,
not
the
doing
ground-
that was that you have not filed any section.
Yes, I have not filed.
Yes.
My lord, the finding was I had indicated last volume 5, page 713, where, my lord, the learned arbitrator has held that paragraph 22, page 713, my lord.
Yes.
And I fully subscribe.
Fully subscribe, yes.
Failure on the part of the respondent to avail of such opportunities in time with notice to and consent of the claimant has created a statutory benefit in favor of the claimant.
Very,
So, my lord,
yes.
he refuses to increase the third figure. And, my lord, there is one other point. I don't know, my learned friend will also not object because I have also sought for partial setting aside. They have also sought for partial setting aside. And on the modification part, my lord, there is a judgment which says that if it is severable, your lordship can, because ultimately, my lord, if your lordship does not go into their case of setting aside, is not wanting to interfere in their matter or in my matter with regard to the limitation aspect and also the security deposit, still, my lord, the case which my second limb of argument, that even if their security deposit is adjusted, my lord, I become entitled to the to a sum just by changing that third figure. So, my lord, to that effect, my lord, your lordship can modify the award. For that, my lord,
Modification under 34 is otherwise very limited.
yes. My lord, is it both side printed?
Yes, won't make a difference.
Sorry, my lord.
No, won't make a difference. Just give the paragraph.
Well, kindly takes 40 page, para 40. It was on a different, it is neither necessary nor proper for us. Lordship has it?
Yes.
It is neither necessary nor proper for us to attempt an exhaustive enumeration of what would constitute the fundamental policy of Indian law, nor is it possible to place the expression in the straitjacket in definition. What is important in the context of the case in hand is that if on facts proved before them, the arbitrators fail on to draw an inference which ought to have been drawn, or if they have drawn an inference which is on the face of it untenable, resulting in miscarriage of justice, the adjudication, even when
made by an arbitral tribunal that enjoys considerable latitude and play at the joints in making awards will be open to challenge and may be cast away or modified depending upon whether the offending party is or is not severable from the rest. So, my lord, your lordship can, my lord, in these facts and circumstances, my lord,
Anything else?
so far as the other point, which my lord, my learned friend has said that no notice was served on 3C. My lord, may I reply to their argument because
Yes, you can comprehensively so that
Right.
you will in reply you will say.
yes,
Well, we'll let
on
them-
that 3C, my lord, there are few letters also and the findings of the tribunal. I'll place those because my lord, 3C I have not dealt with because it was in my favor. In my
What was 3C? I mean, just remember.
3C, my lord, because my lord, the work was not completed. We had done that work through some other contractor.
Oh, that amount.
Yes, my lord. That risk purchase, my lord. And that, my lord, the claimant says that we have not issued any notice under 3C, which entitles me to claim that risk and purchase cost from them.
Yes.
So that is their.
You say that you had.
Yes, my lord. We say we have issued letters.
Those are annexed to the opposition, your opposition to theirs.
No, those are there in the record itself, my lord. Those are there in the statement of claim, statement of
In
defense.
your application also that's annexed.
Yes.
So you can give me the page numbers or you can.
My lord, if your lordship wants to hear me on that
Right now, do that.
Or my lord, once they argue on that point, I can reply on that.
Because then again they'll have to reply on that. Show those. If anything remains after his argument, then I'll take you on reply. Otherwise, no need.
My lord, the first letter, your lordship will kindly take
That
volume.
point, Mr. Dotto, you will be taking obviously. 3C.
This is my principal point.
Achha, let them argue first. If it's his principal point, then let's. Yes, take your seat. Yes, Mr. Dotto.
Lord, just I'm handing over the list of books that we had, the lordship. And the list of documents, because 5 volumes are there. In which volume, which?
You are Konark Enterprise.
Milord, I am placing Milord. Huh? No. This is pertaining to the Milord in which volume Milord the documents is appearing. Because 5
No,
Milord, I am
these two are the same.
No, Milord. The second Milord, the 1-page document is relating to the Milord the document.
These are exactly the same. দেখাও ওকে তো যেটা আমি মেসার্স কোনার লিখেছি ওটা ফেরত রেখে দাও where I have written something. Yes, sir. Handed over already. One is 4-page, the other is a single page document. How many lists are there? 2.
2 lists are there.
You have given me 2. Given me 2. You have given them 1 probably.
Yes, I am giving other also.
The one which you handed up to me by mistake, hand that over. Yes. Now that things are sorted out, what is your argument?
Milord, I am placing Milord so far this my Milord the section 34 is concerned.
In the process, you also reply to them.
Yes. Milord, just I am giving few dates. Milord, contract was pertaining to the construction of the road. All are not German, but Milord, to apprise your lordship, Milord, just this is Milord, I am giving few dates. Milord, the estimated cost put to tender was Milord, the notice inviting tender was issued 13th of January.
Put it in a list of date or
yes. Only the relevant Milord the dates. Just I am placing relevant dates.
Please, I'm not taking a note on that. You just put it in your written notes of arguments.
Otherwise, Milord, I cannot develop my argument. Milord, only the 2-3 dates I will place.
Have you got a list of dates?
Yes, Milord, the list of dates, Milord, I have already referred.
Lost.
2-3 pages document, Milord, I have given to your lordship, Milord.
Oh, this is a list of date.
Fine.
Oh, very well. Refer to the dates.
January 13, 2009, Milord, the notice inviting tender was issued. Then, Milord, on February 18, 2009, Milord, I have participated tender and they quoted the rate. Then on March 25, 2009, Milord, the claimant intimated the difficulty. This is not the relevant date. Then, Milord, kindly come have a look at, Milord, the 4th. May 20, 2009, the running account bills, VD memo number such and such was paid in favor of the claimant. Then, Milord, August 25, 2009, claimant sought for an extension of the time till March 31, 2010 for the execution of the subject project. So, Milord, if your lordship see, there are the, Milord, in 2 occasions when the extension of time were granted. 2 occasion extension of time was granted. And kindly see, Milord, April 20, 2010, the claimant sought for the extension of time till August 31st, 2010. Then, Milord, the rest of the work was done on the May 25, 2010. The respondent, Milord, requested the claimant to complete the balance work. And, Milord, kindly see next page. September 24, 2010, my learned friend also indicated that the subject work was completed. Subject work was completed. How, Milord, this is evinced from the document itself? Milord, kindly take trouble to have a look at Milord, clause 3. Thereafter, Milord, refer to award such and such reply issues. Milord, kindly have a look at volume 4, page 580.
Yes.
Prior to that, Milord, take 578. This is clause 2. Clause 2 is, Milord, pertaining to the, Milord, the imposition of the liquidated damages. If there is any failure or the default on the part of the claimant in executing the work, it is an instrument in the hand of the respondent. They can use it by issuance of a, Milord, clause 2 notice that there has been a delay. I will extend the time subject to imposition of the liquidated damages. In the instant case, Milord, there is no singular instance where, Milord, the liquidated damages were issued or the second clause 2 notice was ever issued addressed to the claimant. It is, Milord, the precondition for imposition of the clause 3. Kindly have a look at, Milord, page 580, appearing at page 580, Milord, clause 3. In any case in which any of the clauses of the contractor.
No, this is your which AP? This is AP 464.
This is, Milord, my application, Milord.
What is the number?
Number 95. No, 95 is the old number.
Okay.
APCOM, Milord, 255 of 2024.
Yeah.
Milord, kindly
14.
take my
14. Side.
my 5 volumes, Milord. Milord, volume 4, Milord, page 580.
Yes. Close to the time.
So I have placed, Milord, the clause 2, 578.
Yes.
Which is the precondition for the imposition of the clause 3. Clause 3 says, Milord, there are 3 eventualities has been mentioned over there. What has been, Milord, the eventualities? Milord, prior to that, Milord, in any case in which under any clause of the contractor shall have rendered himself liable to pay compensation amounting to the whole of the security deposit, whether the paid in the lump sum or the deducted by the installments, the executive engineer and the authorized officer on behalf of the authority shall have the power to adopt any of the following courses or may deem best suited for the interest of the authority. 1. They rescind the contract of which the rescission in the notice and writing of the contractor under the hand of the executive and the authorized officer shall be conclusive evidence, and which case the security deposit of the contractor shall stand forfeited. So, Milord, if they mind to terminate the contract, by invocation of the clause 3A, only simpliciter they will terminate the contract and the security deposit would be forfeited. So what is the condition precedent? Condition precedent is this: there have to be a the notice under clause 2 that there is a default on the part, and if despite there has been a failure, the imposition of the liquidated damages should be there. Even then, I will not execute the work. In that event, they terminate the contract and forfeiture of the security deposit. Next is B. Comply labor paid to employ labor paid by the authority and to supply the material to carry out the work, or any part of the work debiting contractor with the cost of the labor and the price of the material on the amount which the cost and the price to a certificate, or the executive engineer authorized officer shall be final and the conclusive against the contractor and the crediting him with the value of the work done in all the respect and the same manner and the same rates as if it has been carried out by the contractor, where the terms of the contract and the certificate of the executive engineer authorized officer and the value of the work done and the shall be final and the conclusive against the contractor also. So this is also not relevant in my case, because after the completion of the work, admitted completion of the work, they have engaged other agency for to redoing their work and the additional work.
Mr. So Doctor, before we proceed, page 579, the last paragraph, please come back to
579,
The number of days is dotted line only here.
Yes, dotted line, that has been, this is the similar way, how the, all the tenders.
There is no time,
180 days was the principal time, but they did not find time to put it.
No, the requirement of notice in clause 2, which portion of the clause 2 says that? Just show me once again. You said a notice is required under clause 2.
The time is allowed for the work of the entry such and such and the shall be reckoned from the date on which the order to commence is given for the contractor. The work shall throughout the stipulated period of the contract be proceeded with. That means the 180 days, which is the principal, the stipulated date of the contract.
Where do I get that?
Your Lordship is find it out.
Anyway, that will be found in the earlier parts of the document. Yes.
180 days.
So that's 180 days. I'm taking a note here. Yes. Please continue.
And the work shall throughout the stipulated period of the contract be proceeded with all the due diligence, time being the deemed to the essence of the contract. On the part of the contractor shall pay as compensation an amount equal to the 1% of the such smaller amount as the executive engineer authorized officer and the HDA, whose decision in the writing shall be final, may decide on the amount of the tendered amount of the whole work as shown in the tender for the everyday, that the work remains uncommenced or unfinished after the proper date. The contractor shall commence an execution of the such part of the work as may be notified within the 7 days from the date of the order of the commencement of the work, diligently continue the such work and the further to ensure the good progress during the execution of the work. He shall be bound to all the cases in which the time allowed for the work exceed of the 1 month to complete 1/4 of the whole of the work before the 1/4 of the
show me the provision of the notice that they have to give a notice. You said clause 2 says that they have to give a notice.
No, clause 2 says there is a imposition of the liquidated damages if you fail to execute the work 1/4 of the work in the 1/4 of the time.
Yes.
So, this is imperative that prior to imposition of the clause 2 or the imposition of the liquidated damages, a show cause is the sine qua non. This is the general principle. It is not that this clause 2 says that the notice is required to be given. So imposition of the clause 2 or the liquidated damages, it is the
liquidated damage is automatic as per this. There is no scope of any adjudication on that.
No adjudication.
If there is no scope of any decision on that, why should a show cause notice be issued? That is automatically imposed. If you fail to do the work within the limited period, then you are liable to pay that whatever it's called.
But the fact suppose
why a show cause notice at every stage? No show cause notice is given.
Show cause notice is not required. But the liquidated damages.
Why should a notice be given to you at all? As per the term of the contract, they know that you have failed to do the work within the limit.
Assuming that the no notice is required.
Yes.
Assuming that this is before Lords. Assuming that no notice is required. In that event also the section clause 3 is there. So terminate the contract. They have to
clause 2 because I don't find it necessary to give a notice in clause 2. The extension, if they have to say, they have to stipulate this is the extended period. If you don't do the work within that, it's very clear. It is automatic. you become liable to.
So, my lord, the clause 3 and the clause 2 are the dependent because of the reason that, my lord, the termination of the contract is arising out of a default committed by the, my lord, the claimant. So, if the default is not there, in that event, the termination would not be there.
Right.
So, my lord, the default will come if I fail to execute the work within the
time.
stipulated time.
Either stipulated time or the extended
or
time.
the extended time.
Yes.
In that event, there would be a liquidated damages.
Hmm.
So, my lord, the two provisions are there. One is the termination of the contract, other is imposition of the liquidated damages. Suppose, my lord, I have failed to execute the work. In that event, my lord, the instrument is that, my lord, if they impose the liquidated damages, which will not, my lord, wriggle out my responsibility by
But
saying.
Mr. Dattu, the language is not that you have. I mean, suppose they don't take the compensation from you. They don't ask for the compensation even. But this 3 says the language uses not that if any compensation has been imposed on you. It's a bit convoluted. In any case in which under any clause of this contract, the contractor shall have rendered himself liable to pay compensation. That means you have failed to finish the work within that period. Even if no compensation is imposed on you or exacted from you. If you have made yourself liable to pay compensation, then they can terminate. And then these three apply.
So the corollary comes.
You have to have been liable to pay compensation.
So, my lord, certain situations are there.
Yes.
When, my lord, I have failed to execute the work for the reason that my lord, the primary obligation which is required to be discharged with, that has not been discharged with, which, my lord, prevented me from executing the work. That's why they have not
clause
imposed.
3, there has to be a notice.
My lord.
Clause 3 does not require a notice.
I do agree with you, my lord. My case is in a higher echelon, higher pedestal, my lord. So, my lord, kindly leave aside the whether the notice is issued, required is not, my lord. I will not.
Clause 3, whatever is provided, they have to do.
My lord.
So, I leave that aside.
My lord.
Yes.
My lord, because, my lord, kindly 3C.
Focus on clause 3.
3C, my lord.
3C, yes, 3C.
To measure up the work of the contractor and the take such part thereof as shall be executed out of the hands and to give it to the another contractor to complete, in which case any expenses and the which may be incurred in the excess of the sum which would have paid to the original contractor if the whole work has been executed by him, or the amount of which excess of the certificate in the writing of the executive engineer, authorized officer, final and conclusive, shall be borne and the paid by the original contractor and the may be deducted from any money due to him by the authority under the contract or otherwise from his security deposit on the proceeds of the sale thereof on a sufficient part thereof. So, my lord, if I fail to do by dint of the, my lord, the provision of the 3C, they will terminate the contract, security deposit would be forfeited. In consequently, they would be permitted to employ certain persons, where, my lord, by dint of the principle of the risk and purchase, they will appoint a other contractor to execute the remaining portion of the work. And the, my lord, the difference amount, suppose, my lord, the BOQ item was, the rate was X. He has paid the work, remaining portion of the work he has to pay X plus 1. In that event, I have to pay the 1 also, because
although no notice has been envisaged in clause 3, notice has stipulated, but this requires a prior notice, you see. Because there may be various components of dispute.
My lord.
All right.
My lord, kindly take the issue was framed by the learned arbitrator. I draw your lordship's attention at page 571, volume 4.
Yes.
Since my learned friend took the point of the limitation also at the same time, my lord, I will place it side by side.
Yes, right.
So kindly take, my lord, 571. The second issue.
Limitation.
And, my lord, the relevant issue is 6th. Did the respondent rescind the contract in the terms of the clause 3A, B, and the C of the conditions of the contract? Kindly see, my lord. Volume 2, page 293.
Yes.
This is below the measurement book prepared by both the parties, admissible in evidence. Nobody cannot challenge and question the authenticity of this document. Kindly see the fourth and the final bill. Lord, kindly see the entry 1, 2, 3, 4, 5, 6, 7, 8. Date of completion, my lord, 24th of September 2010. Date of measurement was 20th of September 2010.
That is also 24th, I suppose.
My lord, 24th or 20, I cannot find it out. My lord,
Should
the
be
date of
24th
measurement,
because date of measurement has to be on the date of completion.
or prior to that, my lord, there is no difficulty.
Acha. Unless you complete, how can they measure?
No, the measurement would be done and thereafter the date would be mentioned that this is the date of the, my lord, the completion of the work. Suppose, my lord, actual completion has already been done. How that would be ascertained? After the measuring the work, that would be ascertained.
So therefore, measurement can come after completion or on the date of completion, not before completion.
On the date of completion also.
Yes, but not before completion. Unless it is completed, what will be measured?
My lord.
It has to be either on the date of completion or
below-
after. So this cannot be 20th in any event. 20th would take it 4 days before the completion of the
before
work.
the work.
Has to be 24th.
My lord.
Anyway. So why did you place this, Mr. Datta?
My lord, this is the, my lord, the evidence on the basis of which I will demonstrate that the, my lord, subject work was completed. There is no, my lord, the default on the part of the claimant not to execute the work. This is a, my lord, the document which cannot deny by any of the parties because, my lord, this is signed by both the parties.
Where are the signatures?
Lord, kindly have a look at page 88. Volume 3, my lord, page 336.
It's a continuation of the running bill.
Yes. Volume 3, my lord, page 336.
Yes. Right. At least they have signed.
They have signed. My lord, kindly this certificate. I am showing, my lord, your lordship, the certificate. This is certified that, my lord, the measurement book, my lord, at page 88. Your lordship got it, my lord? Page 88, page 366, but the measurement book 88.
Yes. This is certified.
This is certified that the work has been certified.
Completed. On the terms of.
As per the terms and condition.
Right.
They have also, my lord, they signed the document.
They have also signed. Both signatures are theirs. Both are HDA.
Yes.
Very good. So they are bound.
My lord. Then, my lord, kindly have a look at few questions are put in cross-examination. They have replied also. Page, volume 4, my lord, page 513, volume 4. Question number 35. Do you agree with me that the date of the starting was on from 18th of February 2009 and the date of the completion was 24th of September 2010 as indicated in the measurement book? Yes. Do you agree? Further agree with me that the date of the completion as mentioned over the 24th of September. Sergeant,
this is whose witness?
Their witness.
Your this is your cross.
Cross.
Their witness is cross. Right.
Then, my lord, kindly see volume 4, page 529.
Yes.
Did the respondent, page 529, question number 76.
76, yes.
Did the respondent impose the clause 2 of the conditions of the contract? If so, please indicate the document disclosed in this proceeding. No, clause 2 was not imposed. Then, my lord, page question number 77. Did the respondent levy the liquidated damages by imposing the clause 2 of the conditions of the contract? If so, indicate the document such and such. No such condition has been imposed. Next. Therefore, can I take it that despite there being a penal provision for the non-completion of the subject work incommensurate with the time schedule as alleged, no liquidated damages as envisaged in the clause 2 of the conditions of the contract was imposed? Yes.
Imposition of this compensation.
As per your lordship's view, my lord, this is not.
I have taken up. I have prejudged actually.
No, it is not that, my lord. But what I have.
This is an expression of opinion, so that you can controvert that, so that you can dispel my thoughts.
My lord. But the my lord, even if, my lord, if I place it,
because the language uses, you make yourself liable for compensation.
My
Not that compensation has been imposed on you.
My lord, question number 535. 535.
If there was a question number 535, Mr. Dotto, that the award should have been rejected on that ground alone.
No. Page number 535, my lord.
Yes.
Question number 84. What document had the respondent disclosed in support of the said deposition of the proceeding? So prior to that, my lord. 83. My lord, 534.
Yes, 83.
Would be able to indicate the subclause enumerated in the clause 3 of the conditions of the contract, the security deposit alleged to have been forfeited by the respondent. Subclause A of the clause 3 of the conditions of the contract.
This is nothing.
No.
This is A.
Yes. Subclause A of the conditions of the contract, they have stated in which provision you can do that. Then, my lord, no such document has been disclosed.
What document?
Imposition, my lord, the termination of the contract, and my lord, the
this is very vague. This is very vague. Would you be able to indicate under which subclause? Even if you fail to indicate what hinges on that. Sure. If there is a clause, there is a clause. Even if the witness failed to indicate the clause.
But the clause is there.
Yes.
What document had the respondent disclosed in support of the said deposition in this proceeding? No such document has been disclosed.
What is the meaning of this? What document has the respondent disclosed in support of the said deposition in this proceeding? Or in support of the entire deposition, what document you have produced?
So far is the termination of the contract, or the forfeiture of the security
deposition is open-ended.
Yes.
Does not refer to any deposition. This is not a good question in cross. If you say said deposition, where is it said?
So apart from this, my lord, I will not place other questions. Apart from this, my lord, there is no single document on record
to show that they have imposed compensation on you.
Imposed?
That penalty on you.
No penalty was imposed.
I completed your sentence. You say that there is no document to show that they have imposed that penalty on you.
Impose the penalty on me, my lord. There is no single document that I have been so caused prior to termination of the contract, or there is no single document saying that the contract has been terminated, and, my lord, the remaining portion of the work would be awarded to the X for, my lord, completing the work, remaining portion of the work.
So you say at least that had to be read into this clause 3, the prior notice.
Yes. Prior notice is also there, and the fact remains, my lord, since, my lord, the issue has been framed, whether there is a imposition of the clause 3A, 3B or 3C.
So you say no imposition of cost.
Because there is no single document for imposition or prior any so cause. There is no single document also, my lord. And there is a document on record which fortifies the fact that the subject project has been completed. It is evinced from their document. It is not that it is my document. It is evinced from their document that subject project has been completed. Since the, my lord, subject project has been...
That was page 366 or something like that? Page 88 of that? 336.
336, my lord.
Thank you. Yes.
336 of the, my lord, volume 3.
Yes. Right. So 3 points. No imposition of costs or whatever compensation. Secondly, no show cause. Thirdly, the subject project was completed even as per their signature.
Yes.
So you had completed.
Yes, I have completed.
So it was not left incomplete.
My lord.
What did the arbitrator? How did the arbitrator deal with this?
I am coming, lord.
these specific three things.
The arbitrator hold
Hmm.
that, my lord, there has been an imposition of the clause 3A, B, and C. It has been held by the learned arbitrator.
Obviously, it has been imposed, but regarding show cause, what did he say? And regarding this non-imposition of compensation, what did he say?
Nothing has been said.
Nothing has been said. And regarding the last, that subject project was completed, did you argue it in so many words?
Yes.
What was his answer to that?
You kindly see. Just I am giving the reply to the, my lord, their show cause.
No, the arbitrator's take
Yes.
on that.
625, volume 5. Issue number 6.
Issue number 6, yes.
Affirmative in respect of clause 3C.
No, where is the discussion on this? Issue number 6. Let us see where he has discussed it. He has not decided the issue.
This issue has not been decided, and
Any issue has been decided. I don't see any discussion on the issue.
yes,
Is there any caption? The issue
Yes.
number such and such.
you kindly see, my lord, the limitation.
Now, where has the issue been discussed?
My lord, the issue of limitation has been discussed, my lord.
Not limitation. Issue number 6.
So 6.
We are on 6 now, right now.
So limitation 590.
My lord, may I, my lord, paragraph 25 of the award, the learned arbitrator says, for the sake of convenience, all the issues are taken up together for consideration as the same invoice involves common set of facts. So he has not, my lord,
Separately
dealt with.
Thank
But
you.
the limitation has been dealt with separately, my lord.
Acha, let us see that.
598, volume 4.
At least 20 pages go by this setting out of the clauses.
Yes, yes.
Not 20, more than that. Most of the award. In fact, where does his judgment begin? Clauses have been set out.
My lord, so far the limitation may I place?
Where he is, which page?
598, volume 5,
598 on limitation, yes.
on limitation. My lord, their submission is required to be read, my lord. What point they have taken? Mr. Saroti Dasgupta, the learned such and such of the respondent has contended that the claim for the refund of the security deposit is expressly barred by the law of limitation. According to him, the timeline and the proposed by the claimant, the work was completed on the 24th of September 2010. Therefore, as far as the refund of the 30% of the security deposit is concerned, the first installment thereof is entitled, and the cause of action of the claimant starts 24th of September 2011. That is, upon the expiry of the 1 year from the date of the completion. Similarly, from the second installment and the third installment, the entitlement commences on the 24th of September 2012 and 24th of September 2013 respectively. Under the contract, the claimant is not entitled to refund the 100% of the security deposit at one go, but in such staggered manner, the claimant had, however, they invoked the arbitration agreement in the terms dated 13th of December 2016, at which point of time the limitations start running under section 21 of the Arbitration Act of 1996 to be read with the section 43 thereof. Therefore, the 3 years from the each and all of the set of the installment of the all the claims, therefore, they expired on the March before the arbitration was invoked, and as such, the same cannot be claimed and entertained by the learned such and such. And he also invited the attention of the tribunal to the subclause 1 of the clause 40, section 43 of the Arbitration and Conciliation Act of 1996. Under the such section, the provision of the Limitation Act of 1993 is applicable in the present arbitral proceeding. Now, the subsection 1.
So, Doctor, your point, it's very simple. They took a point that it has to be in staggered manner, in a staggered manner, whenever 1 year is completed from each of the payment dates. That was their case, and you say no, whenever for the completion of.
No, subsequently, for the month of April 2016, the final bill has been paid. Unless
No, the point I'm saying, their point was that it has to be in a staggered manner, and you say no, date of completion.
Date of, not the date of completion, date of the making payment. My
Date of termination probably that was taken by the arbitrator.
date of termination and subsequently security deposit comes after getting, my lord, the final bill. Final bill has been paid, my lord, that is I have submitted, my lord.
Your submission I'll then read because their submission has been made at length. So I'll start from your submission at page 600. I'll come back in 5 minutes and start from your submission at page. Yes, Mr.
So kindly take page 600, my lord.
Right, right.
For the claimant has, on the contrary, they argued that the claimant and they made the claim on this not is maintainable in the present form in the such and such pertaining to the interest of the final bill and the which is pertaining to the interest and the claim such and such. It is not in the dispute that there is no claim on the account of the payment of the work and the which has already been executed. On the contrary, although the delay has been made by the respondent in the making payment of the fourth running account come the file and bill, the said amount was paid on 18th of May 2016. Although the work has been completed according to the claimant on the 24th of September 2010, the amount has been paid on 18th of May 2016 as evident from the document disclosed in the proceeding, being such and such. It is also admitted fact that the subject work was actually completed on the 24th of September 2010. If the provision contained in the Article 18 of the Limitation Act is considered, it will appear that the same is enumerated for the price of the work done by the plaintiff for the defendant on his request, where no time has been fixed for the payment. The period of the limitation has been mentioned as for a period of the 3 years, which would be reckoned from the date when the work is done. But according to Mr. Dotto, this article would not be applicable in the instant case as there is no claim for the price of the work done by the claimant. Therefore, the date of the limitation cannot be reckoned from the date of the completion on the 24th of September 2010. This claim would be amenable under residual article of the 137 of the Limitation Act of 1963. It appears from the article 137 that any other application for which the no period of limitation is provided elsewhere, the period and the would be for the 3 years, which shall be reckoned and the when the right to apply accrues. In the instant case, the right to claim for the refund of the security deposit accrues from the date of the payment of the fourth running account come final bill on 18th of May 2016 as stated before. He has also drawn the attention of the such and such and will appear and that the said letter dated 1st of July 2016 issued by the claimant.
No, there are two components to your argument apparently. One is that you don't claim the amount for the work done, but the interest. So
not the interest. Only security deposit and interest on the security deposit. So, my lord, unless the final payment would not be made, the issue of giving, my lord, security deposit does not arise. I have to get the final payment first and thereafter, my lord, because the final payment, because all the earlier payments, running account bills are the ad hoc payments.
But the agreement itself links the payment of security deposit with the completion of the work.
So unless,
as per the agreement, even if they don't, suppose they don't pay.
No, in a normal situation, what happened? So there is a completion of the work, final bill would be paid, and immediately thereafter, the security deposit.
So, whatever happens in a normal situation, as per your contract, the security deposit repayment is directly linked with the completion of the work within a particular period. Default liability period or something. It's after 1 year probably it is to be paid. So it starts from.
Yeah, there is 3 phases.
For the 3 phases, right? For the 3 phases, three dates. Now that is irrespective of the payment. Even if they don't make, for example, if they don't make any payment on the bills, even then that security deposit claim starts. You can claim independently the security deposit claim even without any payment being made.
The security deposit, my lord, forms on the basis of the each and every bills.
Yes.
Each and every bills, there would be an amount of the 10% that would be deducted and that would be kept as a security deposit. So, my lord, the final bill, all the payment which has already been made, this is a situation, peculiar situation, where, my lord, the payment has been made in a belated stage. In the year of 2016, although the work has been completed in the 2010.
Even if they didn't make the payment, how do you connect the security deposit?
I am not entitled to get security deposit.
But as per the agreement, you are entitled to get security deposit once that percentage.
You know, security deposit comes if I would be able to complete the work. If I would be successfully complete the work, in that event, the executed portion of the work, the paid would be.
Completion of work is not linked with the date of payment. Completion of work, whenever the completion of work is done, you are entitled.
Kindly see the clause of the making payment. I am drawing your lords.
It has no nexus with the payment. Which page in your document, Mr. De? There, your application, which page you saw showed me that clause?
That clause, my lord, page 99
99.
of volume 1.
Yes. Release of security deposit, that. You can take your corresponding page, Mr. Datta, no difficulty. I'll just see the. Yes, please take your seat, Mr. I've got it.
My lord, this is clause, my lord.
Number unnumbered.
Authorized to make payment.
It is captioned release of security deposit. Oh, I'm looking into a communication by them. No, this is that agreement. The security deposit within bracket 10% of executed value, that clause.
My lord, what has been set out, my lord, in the, my lord, the award, my lord.
Yes.
Just I'm finding out on. This
They
is
never
mentioned in
dispute.
the work order, my lord.
Pardon?
This has been mentioned in the work order what they are showing, my lord, the release of the security deposit.
Yes, but this is not the actual clause.
This is in the work order. Work order.
Work order, yes. Work order is what we have to do.
There is a specific clause in the, my lord, the condition of the contract also, my lord. I am showing.
You can show that also.
The release of the security deposit of the 10% executed value will be released to on the properly maintenance of the road, including such and such of the 3 years from the date of the completion and handing over of the HDA in the proper format. The schedule of the release completion 30%, 30% and 40%.
So therefore, it's very
I
specific.
want to show my lord, the clauses of the, my lord, the making payment. So kindly bear for a moment.
Show me that.
Conditions of the contract. Just a minute. $98 things. Volume 3, my lord, page 365.
Yes.
Litigation of the performance. This is also notice inviting tender. Clause 2.11.
This culminated, this merged with the contract work order, because the work order is your contract basically.
No, my lord, there is a, my lord, the clause 2911. There is a, my lord, the payment.
Is there any other contract with you apart from the work order?
Yes. This is
separate.
the form number 2911.
Very well. You can show from that also or the tender, whichever.
2911. Because I have focused only on the, my lord, the award, and that's
Yes, absolutely. No difficulty.
Notice inviting tender on the 13th June 2022 as in such delay of the completion of the performance in the terms of.
Show me the part of the award which deals with this.
The limitation has been dealt with in 691. Second paragraph, my lord, the finding. although I have, my lord, submitted in page 600, but it has find it out in 691. Just prior to that paragraph, my lord, I have to place. Page 690, my lord. In the meantime, the claimant and the wrote a letter dated 7th of March 2011 of the exhibit such and such intimating her inability to continue the work in response to the 3 letter and the mention above receipt and the by her from the respondent. In the said letter, he has categorically stated that he was facing great inconvenience to complete the work as the local people forcibly stop her and by working idle labor and the machineries, as a result of which he was sustaining the heavy loss. In spite of such obstacles and from the end of the respondent no tangible action such and such, as a consequence, the construction of the twin box bridge and the approach road and the rectification of the BM work was satisfactorily completed. But at some stretches from the starting of the road of the middle of the village such and such, no work could not be taken up, and due to the obstruction of the local people in spite of the several persuasions from the end of the respondent as well as the claimant. According to the claimant, the attitude of the local people was not such and such, and they to the threatened as he could not satisfy them, the people and the forcibly such and such and the damaged. This letter of the coming from the custody of the respondent in the annexure such and such of the such and such. Therefore, the claimant expressly conveyed that the she was not in a position to execute any further work at the site and as such requested the respondent to terminate the contract, but not to impose any penalty as he had no willful negligence and the complete the work and due to the possible agitation and the paid for the balance amount of the payment of the work done by her. The consequent action taken by the Chief Executive Officer of the respondent and the receipt of the intimation dated 7th of March 2011 is not forthcoming, though in the subsequent letter dated 29th of March 2011, the claimant reiterated her earlier grievance and ultimately requested the respondent to authorities to terminate the contract honorably and the arrange to pay the final bill for the completed work done and the security deposit money lying with the respondent. Therefore, the inevitable conclusion from the correspondence will affirm that the tenure of the contract expire on 1st of March 2011. Because subsequent few letters are.
But what does it have to do with the security? It has to do with the tenure of the contract.
No, this is pertaining to the limitation. Then the next paragraph. If that is so the period of the limitation of the defect liability period of the 3 years will commence from the 2nd March of 2011 and up to the 1st March of 2014. The period of the limitation of the 3 years in the instant case and will be up to the 2nd of March 2017. The present claimant and the resorted to the arbitration admittedly on the 13th of December 2016, following the demand letter dated 1st of July.
No, limitation is the question which we are considering here. But limitation for claiming security deposit starts as per that clause, release of security deposit clause. And now what does it have to do with the tenure of the contract?
Well, I am telling you, Lord. I am showing that certain documents when the work has been completed. They have produced other document when my client wrote that I could not execute the work due to my personal difficulty. I could not execute the work.
So this destroys your other case, which you said that running page 88, internal page 88, that they have signed what is concluded, completed.
This is my lord.
Completed, and you write thereafter that I have failed to complete the work.
What is there? That is there, my lord. I cannot develop. But my
that is the precise problem with, for you.
The difficulty.
Because you cannot develop. Even if you showed that document, page 88, that internal page 88, they signed that work is completed.
But
that was a component of the work.
But the fifth.
You write thereafter, I have
failed. But Lord, I will produce before your lordship, my lord, that this document which has been cited before your lordship, we have in my admission and denial of documents, my lord, we have denied the existence of the document. They have not taken trouble to prove all those documents. I can place it with affidavit, my lord. So this document, what has been referred, by my learned friend, my lord, has not been find place in the my lord, the award also. And my lord, in the first proposal was before the my lord, the Honorable Justice Kapoor, that my lord, since my lord, this award has been messed up, even here in the 33 application also. So we have sought for that the stage where the evidence has been taken, set aside the award. In the first day I have stated, set aside the award in the entirety, send back to the my lord, the arbitrator appointed by the court. I am agreeable to do it, my lord, there is no difficulty, because I am also not convinced, because my lord, if I am entitled to security deposit, the parts of security deposit cannot be granted. If I am entitled in its entirety, but part has been given. Which condition the part has been given, I don't know. So if I am entitled in entirety. Otherwise, I am not entitled. The two things cannot be done side by side. Half that would be given. It is not the charity.
Why has the part been given to you? What is the ratio of that? What is the reasoning for that? A part being given?
Part is given before, my lord, the calculation there is an erroneous entry in the, my lord, the award. I have made an application section 33. They have rectified the said amount. But he has allowed, my lord, the awarded a counter claim. Counter claim has been awarded of 6 lakhs. Subsequently, the computation which is ought to have been made that has not been made, naturally, if that would be given effect to, that the, my lord, that amount would be more than the award which has been given to me. What is? So it was my first proposal before the Honorable Court that, my lord, kindly set aside the award. I am conceding to the prayer of my learned friend, but learned friend is, my lord, he is not agreeable to do it. So only that stage where, my lord, evidence has been completed and thereafter the decision would be taken. As per the section 15 of the, my lord, the Arbitration and Conciliation Act.
But the arbitrator fully agreed with your views. That is strict on limitation.
Yes. My lord, limitation, there is no case, my lord. Limitation so far is that because, my lord, the payment has been made subsequently, I will place before your lordship, my lord, that the amount which is, can be fine place, my lord, there is a clause 5 or 7, my lord, just
What does this payment of the amount for your work, the dues for your work, what does that have to do with the security deposit? You are claiming the security deposit, Mr. Doctor.
Security deposit amount would be quantified on the basis of the different bills. If the bills would not be crystallized, the amount of security deposit would not be crystallized.
Security deposit by definition means it is given at the inception.
My lord, in each and every bill, part of the bill.
When did you deposit the security deposit?
Initially, my lord, there would be a performance security at the time of the participation in the tender. That part has been termed into a security deposit, and subsequently
you are wanting that only. Whatever was deposited in the name of security deposit, you are wanting refund of that amount. It's as simple as that. It cannot be dependent on subsequent work.
Kind correction, my lord. Initially, I have deposited an amount at the time of
10% something.
No, not the 10%. At the time of the participation of the bid, which has been earmarked over there.
Which is the security deposit?
Subsequently, that has been turned. Suppose since I am a successful bidder, that amount has been turned into a security deposit. Along with, I have to pay the 10% of the each bill, running account bill, that would be deducted, and that would
then
be.
Show me that provision from the either the tender or something.
Yes, I am showing you.
The definition of security deposit, I am not clear on that.
Yes, no, I have to.
As per your contract.
Yes, I have to.
Show me that first. If it can be linked with the payment to be made, then you have a very good case. Show me that. That is linked with the payment. What is security deposit as per the contract? It has been defined at page 98 of their document. It is there in the work contract. It's
contract starts, Miller. Kindly see, this is illegible here. I think that, Miller, it is. They have disclosed in their statement of defense, which your lordship can find it out. Our volume number 1.
There, page 98. I find it.
No, kindly page 58 of my, Miller, the volume 1. Page 58 of the volume 1.
Yes. Page 58 of your volume 1. Let us see that. Yes.
Then, Miller, kindly have a look at page 60.
No, where is security deposit defined?
I am coming, bro. I am coming.
Come there directly.
Oh, page 98, your lordship is.
Page 98 of their document. Just come there. It is defined there in the work order itself.
Security deposit, an amount equal to the 10% of the running bill to be deducted. Yes, Lord. This amount. This amount is deducted from the bills of the contractor subject to the maximum of the 10% of the contract value. This security amount plus initial security, what I have submitted here. in the form of the earnest money and they will be released as per the clause such and such of the such and such.
What is clause 3, page 18 of the printed tender form? It refers back to that.
And completed time also mentioned 180 days, what your lordship was. pointing.
So 10% of each running bill, but Mr. Dotto, then also it is fixed at the date when you raise that running bill. When you raise the RA bill, on that date 10% of that is fixed. It depends on your bill, whatever you raise as a bill. You raise the bill, running bill.
The procedure is this: raising the bill, my lord, it does not arise. Only, my lord, kindly see that the procedure has been.
No, procedure has been given here. Whatever is there,
Kindly
is
see
there.
clause 8, appearing on page 60.
Page
60 of the volume 1.
Your volume 1 or there? Page 60, yes. Page 60, which one?
Clause 8.
Clause 8, yes.
A bill shall be submitted by the contractor on the execution of the substantial work of the work executed in the previous month and the engineer in charge authorized officer.
That is the running bill.
Yes, my lord. The cause to be taken and the requisite measurement for the purpose having the same verified and the claim of the admissible adjusted possible before the expiry of the 15 days from the presentation of the bill. If the contractor does not submit the bill, the engineer in charge may depute the subordinate officers to measure up and the work in the presence of the contractor whose such and such of the signature, measurement and there will be sufficient warrant, and the engineer in charge may prepare the bill subject to the such and such, such and such. So normal procedure is being followed is this: on the basis of the executed quantity of the work, there is a printed form prepared by the the department.
What is that? Clause 3 of that printed form.
Clause 3,
They have referred to clause 3 with a page 18 of printed tender form. What is the tender form?
Running account bill এখানে annex করা হবে।
Page 18 of the, very well, the previous page, probably. Clause 3, page 18. Yes, yes. Please come to page 96 of their document. It's there. Page 96 of their document. The clause 3 under additional terms and conditions, something is there. After the chart.
The security money of the 10% of the contract value would be released in the 2 equal installments. First installment after the 1 year passing of the defect liability period, and the second installment in the completion of the second year of the defect liability period, and provided the work and the pass at least on the monsoon of the release of the installment of the monsoon thereafter and the release of the installing.
So this has been summed up in that work order at page 99.
Kindly see 1. What the initial amount is required to be paid, that has been mentioned in the 1. The contractor will have to submit their bid, earnest money, which has been the earnest money in the form of the demand draft and the pay order. 2% of the estimated cost put to tender subject to the maximum of the 10 lakhs. So initial deposit is this one. The subsequent amount will come in each and every bills, 10% of the every bills that would be deposited along with the initial amount which I have paid, which will forms the part of the security deposit. Page 9.
Mr. Dattu, the scheme contemplated in that clause and the work order and everything apparently is security deposit comprises of the initial money which you deposited, that earnest money or whatever, at the inception, plus 10% of each running bill of the running. Now that 10% is deducted at the point when you raise the running bill.
If I don't raise, it is the obligation on the part of the executive engineer to raise the bill. in consonance with the provision of
If you
withdrawal
don't
right.
raise a running bill, it will be 10% of 0. 10%, the additional amount only accrues if you raise a running bill. It is dependent entirely on the running bill, 10% of the running bill. So running bill you raise, that 10% is added. You raise suppose 3 or 4 running bills, those 10% are added to that pool. That comprises the entire fund of the security deposit, right? Now, when is it payable? That is provided in page 98, which says that after 1 year of the default liability period, defect liability period, 30%, 30%, 40%. So that is relatable to completion of work. Undoubtedly, completion of work has to be after the running bill is raised. Running bill by definition means the work is running. I mean, the work is going on. So running bill is raised, 10% gets deducted, another running bill, similar. Ultimately, work is concluded. When the work is completed, after that, defect liability period, in that manner, it will be disbursed in a staggered manner. So therefore, it has nothing to do with the payment of the bills, actually, Mr. Dotto. You have shown me nothing to link the security deposit refund with the actual payment of the bill. It has to be the date of completion of the work. However we go, it relates back to the date of the completion of the work.
We have categorically stated that this is the date when the subject work has been completed. It is their case that the subject work was not completed. By furnishing the few documents, court has taken the tribunal has taken a view that the subject work has not been completed because there is a letter on record which says that I have requested the authorities that the subject work, I could not complete the work, you give me time, and there is an obstruction or something else.
That was not given.
So that is not given.
So as far as you are concerned, the completion of work is the date when you...
Yes, 24th of September 2010.
Right.
And my lord, the procedure is raising the bill is the printed form normally provided by the the authority. And there is no scope for raising bill on the part of the contractor. Because the bills are normally prepared, taking extract from the measurement book. They are the custodian of the measurement book. The measurement book will contain the executed quantity of the work which has been mentioned in the measurement book, what I have shown. Subsequently, this document has been delivered during the trial. That's why I have been able to produce it before your lordship. So since that was there, they would be able to raise the bill and make the payment on the basis of the measurement book. So since the payment has been made on on a May 2016, and subsequently the issue of coming the subsequent payment arises because otherwise the amount would not be crystallized according to my understanding, So therefore, it would not be barred by the limitation.
Yes. What about the next point? Other point? So, but what is your challenge based on?
My challenge based on is awarding the counterclaim. Only the awarding the counterclaim. If I am entitled, so there is no single document on record which will say that the subject work was terminated. Their case is the subject work was terminated. If the subject was terminated, they would be able to establish. In that event, I will not get single paisa.
Their counterclaim is confined to getting back from you that amount which they paid to the other contractor.
Yes,
that is the counter.
Yes, only that amount. And
so
along,
you say they're not entitled. Along with?
Along forfeiture of security deposit, I will not get any security deposit. So if they would be able to establish that the termination has been made by them by issuance of the letter of termination.
Here there is no letter of termination.
No letter of termination. I would be out of court, they would be able to place it. Only there is a letter at best saying that if you don't do it, I will terminate.
Oh.
One or two letters are there. That is after 2011. So, in that event, if they would not be able to establish that, the subject work was not terminated, so, they are not entitled to get, the counterclaim. And if they would be able to establish in that event, this calculation will not do because, I will not be entitled to get security deposit. It is consequential forfeiture of the security deposit. It necessarily follows.
But the learned arbitrator proceeded on that premise. No, the
arbitrator.
arbitrator No,
I
no.
cannot understand, my lord, in
The
which
arbitrator also gave allowed their counterclaim.
arbitrator, my lord, they allowed the
Actually, I am
counter-
getting messed up. Yes.
No, my lord. We have already, all has been messed up. If your lordship say, I will place it, my lord, section 30, the
No. What did the arbitrator do regarding their counterclaim? Tell me that. I won't look into the order first. Award first. First you tell me, then I'll look.
allowed our, my lord, the claim, refund of the security deposit.
Partially on what logic? Why partially?
Because, my lord, since subsequent letter is there, all work has not been completed. So, my lord, there is no, my lord, the speaking order in that regard.
Acha, very well. Why was their counterclaim allowed? Because if you are
somebody-
entitled to even 1 paisa of that security deposit, then there is no forfeiture.
Yes. But, my lord, since other person has been appointed or engaged for doing the remaining portion of the work and they have incurred an expenditure, I have to pay it. Although there is no termination.
Forfeiture and other person payment is intertwined, inextricable. Both have to come together or neither of them.
Three eventualities are there. They are telling the eventualities engrafted in the 3C. 3C says forfeiture of security deposit and, my lord, risk and purchase. Risk and purchase means if somebody would be engaged in that event.
Yes, both occur once your contract is terminated.
When the contract would be terminated by invoking clause 3C, they have to establish before your lordships that the contract was terminated by imposition of the clause 3C. Single document is not there. So my case is better if, my lord, they will place their case by producing a document to that effect that, my lord, the subject project has been terminated by invocation of the clause 3C. If they would be able to produce.
So now conclude your arguments and I'll take it on your written notes, whatever, and I'll give them a chance of replying.
So far as the, my lord, the other, my lord, the judgment is concerned, my learned friend is showing judgment, but, my lord, your lordship is having very limited with, my lord, the subject to your lordship kind correction, very limited scope of modifying the award.
No doubt about that.
And, my lord, two judgments are there. I will not place it.
No, why not, please? Whatever he had to do, he has done. Now you also do whatever you have to do to the court. No, section 34 judgment is definitely set. Site 1 or 2. Section 34 now is well settled.
So, my lord, section 34 I am not giving only. My my lord, issue is on the patent illegality.
You want to shock the conscience of the court, basically.
In any ways.
Either way, yes.
Either.
Both of you are already shocking the conscience of the court.
2021 9 SCC page 1.
If you have got copies of those extra
Yes,
copies,
yes,
then
yes.
then I'll not record.
I'm having
Yes,
copies, my lord.
I'll just take it.
No, Sangov to 2019.
Give the citation for them.
2021 9 SCC page 1.
Any particular paragraph?
Paragraph 17, my lord. I will not place, my lord. Paragraph 17, 31 to 41.
1734 is quoted.
Yes.
That is the dictum of the Supreme Court. This was more on more with regard to infrastructure projects, non-interference in infrastructure projects.
No, my lord, the provisions is also there that the impermissible power to
17th
modify the
provision has been quoted.
Well, just I will refer, my lord,
Paragraphs. Achha.
Paragraphs, my lord. Just I have written, but I have missed. Even in the, my lord, the McDermott also it has been mentioned, my lord.
Modification in section 34 is extremely limited, if at all.
Even in McDermott also that has been in 2 lines that has been mentioned. My lord, just I will give the, my lord, the just paragraph. It is I have read, my lord, just I will give the paragraph, my lord. And so far as the patent illegality is concerned, my lord, I will not place other decisions, my lord, because associate builders and subsequently, my lord, the state of Chhattisgarh versus Saludyog.
Para 31 is your paragraph. Thus, there can be no doubt that given the law laid down by this court, Section 34 of the Arbitration Act 96 cannot be held to include within it a power to modify an award. And it goes on, the sheet anchor of the. In fact, this is the only, I don't know of any other judgment. The judgment cited by your learned friend, there only I find that Justice Thakur mentions one sentence in a straight sentence modification also. In modification, otherwise it's moral, consistent view and well settled that you cannot modify in section 30. Not even remand. I mean, mostly.
There is a provision of the 34.4, my lord. 34.4 is there for a limited purpose, you can send it, my lord. After amendment, my lord.
Very well.
So my point is on the, my lord, the patent illegality. If I will win in that event, my lord, the no obligation would be for giving counterclaim. And if, my lord, they will win in that event, my lord, I will not get any farthing.
Very well.
My lord, I will give a short notes of argument.
Read notes of argument. Yes. Yes.
I come back tomorrow, my lord, with the reply.
Give the reply, finish it over. You can come back tomorrow also. I can take up other matters. Very well. Come back tomorrow. Very brief reply.
I'll take 10 minutes.
Take 10 minutes tomorrow and then just the written notes I'll not compel you to file tomorrow. I'll give some other date. Prepare your written notes, brief written notes. But to be brief, you have to devote more time. So come back some other. Well, heard in part for further hearing tomorrow.
My lord, should I mention the clauses of the contract which are relevant so far as the payment is concerned and bill is concerned?
Yes, not too many clauses. Probably 3 is important. Clause 3 is important.
3 and, my lord, how the bill would be raised and how the, my lord, that
was clause?
Clause 7.
Yes. 3 or 4 clauses.
My lord.
Right. You can do that. Mention the clauses, mention the page numbers where I find them. This much. Thank you. No, ঠিক আছে আচ্ছা
Item number 50, Asansol Durgapur Development Authority.
Yes.
Not for the petition.
Right.
Well, this disputes arises from JNNURM project, Jawaharlal Nehru Urban Rural Mission. My lord, in which the Asansol Durgapur Development Authority was the nodal agent, my lord, the agency, implementing agency. And the project was in respect of building of 2 sewerage treatment plant in Raniganj and for the pipelines. And award and the contract was granted in favor of the claimants. Well, it wasn't completed in the time limit that was fixed in the contract, and accordingly a number of time extensions were granted, and thereafter it was determined. And in actually, the fact is that, and they preferred the arbitration was initiated on their behalf, and
the subcontract is you subcontracted the work to them.
So we are
the nodal agency.
I am the implementing agency.
What's the principal?
It's the central government. Central government provides.
Central government through you allotted the work to him.
Yes, my lord.
Very.
But the contract is between me and the IDDA and the.
But there it is indicated that you are a nodal agency or no?
Yes, it's an implementing agency.
Something of that sort.
But the central government, my lord, and candidly speaking, has no stake in this particular contract except by providing the money.
Anyway, the arbitration clause is in this contract. So
this contract, that is why.
Yes.
My lord, there are as many as 9, my lord, under 9 headings, there were claims were made, and the learned arbitrator are allowed.
They made the claims.
My lord.
Primarily for non-payment of the dues.
Non-payment of dues.
Pardon?
RA bills, your lord.
RA bills.
Dues. My lord, firstly, my lord, they challenge the determination of the contract, and secondly, they claim, my lord, the pending RA bills and also loss of profit and
security deposit
security
also.
deposit that happens in any other contract.
Yes.
My lord, the learned my lord arbitrator my lord has passed an award in which my lord a part of the claim has been allowed, the loss of profit has been allowed, but the unproductive labor price escalation it has been disallowed on the ground that they were not being able to prove that they had employed my lord people
Such
and
so many people and all.
but even that be the so the loss of profit has been allowed. This is my first point, my lord, in which my lord I want to my lord, and also my lord the point is that the determination of the contract in which our main contention was that one of the contentions was that everything were obtaining permission from the concerned authorities, like it was for laying the underground pipelines for which jack pushing needs to be done for the railway track, and in order to lift it and in that respect my lord, they need to take permission from the concerned railway authorities, and that's in the contract, it's within the scope of the contractor. Our ground was that within several other grounds that was not done on their behalf. So apart from not clearing the roads after excavating them, not completing the project, but it has been held by the learned arbitrator that jack pushing is in our scope. Not our scope.
You have reached up to jack pushing.
Well,
Then yes.
and secondly, my lord, the next point, my lord, is that the determination of the contract was 19th of January 2015. Even after that, they were continuing with the project in spite of being prevented by the authority. And we have asked them several times, and those are exhibits in the arbitration.
The arbitrator held what regarding the termination? It was justified.
Termination has been held that it is incorrect in the incorrect.
Did you give any notice or any hearing or whatever?
That show cause was given. After show cause was given, it was determined.
So on what ground was it held to be invalid?
Invalid is that we have not performed our part of the contract. Like the just now, Milord, I submitted that jack pushing part. It's one of the grounds. And
are these 34 amenable to 34 jurisdiction?
My lord, but admit, my lord,
this is not a regular appeal.
My lord, and
what is so unconscionable, or I mean, whatever are the grounds in 34? Apart from his appearance, anything else?
My lord, and next point is that, my lord, admittedly, my lord, on 19th of January, it was determined and they were raising bills even after that, continuing with the work.
Is there entirely factual appreciation of evidence? Mr. Banerjee, why should I look into it at all?
I was also, my lord, wondering why should your lordship, my lord, so far as my 36th application is concerned, my lord, I'm told, my lord, kindly do not record our consent as such.
You have filed a 34 as well as 36.
Yes.
This item is item 30, section 34.
36, I mean,
item number 35.
35.
Item 35.
So if my lord kindly puts us, my lord,
item 35, section 36, and section 34 is item
my lord, this
15. Very well. Yes.
So if my lord kindly, my lord,
so I'll dismiss the section 34 and take up the 36. Do you say that? And I'll make it an order of the court.
kindly, my lord, stay operation of the award subject to, my lord, any condition which my lord deems fit. My lord, 8 crore.
What is the operation of the award?
My lord, kindly allow me, my lord, to go through the section 34 once it come. But in the meantime, if my lord,
IFSC show me some case to grant a stay. Why should I stay the award at all? There has to be a very strong ground, Mr. Banerjee, you know very well.
Yes. My lord, I could not prepare myself, my lord, properly, my lord, because of some bereavement in the family. My
Then
lord,
I can take it up tomorrow, no difficulty.
may it be, my lord,
Section
then
34 I find
may it
up
be in
to
the
now,
next week. May it be in the
next week. Yes, I can keep it next week. I'll keep it next week.
But I believe, my lord, in the meantime, my lord, this should not be put into execution.
Your lordship, since my learned friend has
Section 36 as well as 34, I'll keep on
yes
on the same.
the execution is already in place.
Oh.
It is moving in Asansol court. The date is on it is fixed on Saturday, 6th of July. And there where my learned
So
friend
section 36 is in Asansol court.
execution.
Execution
Petition.
Petition.
Commercial.
Commercial. Asansol commercial. And they filed a maintainability application, your lordship.
So if my lord kindly grants us a liberty, my lord, to seek an adjournment on.
No, I don't understand. The award has been challenged here, section 34. This section 36 is before the commercial court there.
Yes, your lordship.
How
Not
can
the
that?
36, the execution petition
Your Lordship, Asansol Durgapur Development Authority is the
Citus,
petitioner in this particular matter, section 34.
Acha.
On that basis, assets lying within the jurisdiction of that court, so we have made
But
a
section 36, please clarify. I am newcomer. You clarify to me. Section 36 is the enforcement of the award.
yes, Your Lord.
36 is enforcement of the award. Subsection 2 of section 36 is stay of operation of the award subject to certain conditions below order 41.
Yes, but
Now,
that has to be
not
by the
not
36 court.
Not before the executing court. Milord, that I can file, Milord, in before the honorable court, where, Milord, I have moved my section 34 application, because at the end of the day, my lord is going to hear section 34 and to see, Milord, the
Now, how can the execution be levied before the
Milord, that's why we have, Milord, taken out a maintainability application there also.
Yes, that is what I am asking. How
We
can
have-
the execution be there?
That was his choice. Milord, we have filed an maintainability application.
Your Lordship, after Sundaram Finance judgment of the Honorable Supreme Court,
Yes.
the law that is now prevailing
Yes. Is
anywhere the award debtor has any asset in that jurisdiction, you can.
but section 42 does not come in.
No, Your Lordship, not in this case. Subject to correction, Your Lordship, not in this.
Please satisfy me on that also, because I'm not aware of this.
We are arguing this before the learned executing court. We are arguing this, that, Milord, that court doesn't have the jurisdiction to entertain execution.
Very well. So I'll keep this 34 then next week.
34 as well as, Milord,
See,
36.
I'm not satisfied regarding grant of stay.
Not being also.
If you have a maintainability ground, Mr. Banerjee, you can agitate that first before that court.
Before that court. Milord, that's, Milord, a completely different aspect of the matter. But, Milord, I need to satisfy my lord's concerns that, Milord, there is at least something, Milord, that warrants my lord's, Milord, intervention. Milord,
You don't have to satisfy me. You have to shock my conscience.
Milord, try to
If you
first
satisfy my conscience, you don't have a case in 34.
I'll try,
No,
first
anyway.
try to satisfy.
When should I keep it? Give me a date, Mr. Banerjee. When will we
Milord, a week after, Milord, 7 days after, next, Milord, Wednesday, subject to, of course, my lord's kind convenience.
Lordship, whatever.
And, Milord, may we have a liberty to pray for, Milord, an adjournment before the learned executing court, Milord, on Saturday. Milord,
I'll not say anything on that, Mr. Banerjee.
Milord, a one-liner would, Milord, very
Nothing in your section 34. Apparently.
as of
Apparently.
now, Milord.
On the prayer of learned counsel for the petitioner, let the matter stand adjourned till July 10, 2024.
Yes, Lordship.
Milord, I just, Milord, indicate one thing. Just let me-
Yes.
I can.
Item 15.
As well as, Milord, 35.
35.
That is, Milord, my 36-2 application for
Very well. তাহলে 35 এ করে দিন। 35 এ একটা সেপারেট অর্ডার করে দিন। On the prayer of learned counsel for the of the petitioner, let the matter stand adjourned till such and such date or একই date to be listed along with অন্যটা 34.
The only question, Milord, which may shock my lord's conscience is, Milord, that after termination, if, Milord, without challenging the termination and getting, Milord, the termination notice set aside first, someone does something, Milord, whether he is entitled, Milord, to, Milord, the billed amount in pursuant to the work, Milord, done after termination.
No, partially it was done by them. After that, it was terminated and it was allotted to somebody else.
Milord, 3 bills have been directed to be paid under the award.
Yes.
14th, 15th, and 16th.
Yes.
14th bill pertains to, Milord, the work done before termination. 15th and 16th, Milord, bills pertain to the work done after termination without the termination notice having been set aside by any forum. So whether, Milord, the learned arbitrator could have done that.
That portion only. Let us come back. In 1 day, 7 days, nothing will happen before the executive.
But I believe so. I hope so. Grateful.
Thank you. Next.
Item number 16, Union of India.
I appear for the respondent petitioner for expeditious hearing. I'll tell you, my lord, the difficulty. We have got an award for 29 crores. My learned friends in 2021, my lord, in March or something, they filed a application under 34. Then they have put in the money. To be fair, they put in the money in court. After that, we have made, I think this is our 5th application to be heard. It's, unfortunately, every time the jurisdiction changed. My learned friend has also begun on 2 days. We've heard him. So I have some priority because now the 29 crores has been lying there. after 2 years, we find out that it wasn't in an interest-bearing account. Then Justice Kapoor passed an order. Now it's lying in an interest-bearing account. Then Justice Moushumi Bhattacharya had also given us leave to take out the money by way of giving a bank guarantee.
You have done that also?
No, this is the problem. That's why this application, our Bank of Maharashtra, Malad, they agreed to give the bank guarantee, but they had certain conditions. They mentioned it themselves before the court. And Justice Bhattacharya obviously got angry and said, my order is very clear. So after that, they backed out and they filed a section 7 against us in the NCLT last week. We have received, we've got 2 orders. We are yet to receive the petition. So if this money is there, the claim is the challenge is very short. It's really to do with the contract had been terminated. They invoked the bank guarantees and security. And that is the bank guarantee. I'm going on paying 92,000 per day apparently.
You have challenged the award.
They have challenged.
What is your primary ground in the challenge? What is the primary?
First of all, my lord, the termination that was it was a legal termination, and that was never been taken in the statement of claim. Also, they never challenged.
Take some time. I'll fix it on some date then.
On Monday, my learned friend was saying he's ready. We are not ready. We'll have to get ready. But as far as my learned friend, he has started before 3 judges.
No, I'll fix time limits then. I'll put it in my order. Let us start that practice. I'll give half an hour to each of you. Half an hour to each of you. And that will be the only ground of this expedition, allowing this expedition hearing. Half an hour to each of you. Come prepared with the written notes. We have to fix timelines because arbitral tribunals everywhere fix it. All over the world. We are not doing that. So since I'm taking up arbitration matters, I'll be like a
one is
institutional arbitration everywhere time limits is fixed. All of you know. All of you know. I'm the person who knows the least in fact.
No, my
but all of you know that institutional arbitration everywhere time limits are given, times are given, slots are given.
If the advocates are told and they know there is a time limit, they will keep it.
Exactly.
What happens usually is halfway through, then if the time limit is given, then we come prepared like that.
Then you cannot prepare yourself.
There are several arbitrations I've done over in 4 days. And some are 14 years, but those are also needed.
I'll give you half an hour each, plus minus 5. I'll put that in my order.
And then Monday, if it may, because they are going to move their application, section 7, my lord, we've managed to get a date.
Not Monday, Mr. Ghosh, Monday probably I fixed certain matters. I'll keep it the week after that. On 15th, that Monday, Monday week. I'll keep it Monday week.
Then I'll direct them to give notes. We'll also bring
notes, exchange notes. I'll put that in my order.
Yes.
Learned senior counsel, upon going through the averments made in the application for expeditious hearing, I am convinced that the matter requires an early hearing. Full stop. However, in view of the constraint of time, due to the heavy list, it is made clear that both parties shall be allotted 30 minutes within bracket plus minus 5 minutes bracket closed each for making their submissions on the challenge under section 34 of the Arbitration and Conciliation Act 1996 on the returnable date. Full stop. The parties shall, in advance, exchange their proposed written notes of arguments sufficiently prior to the next returnable date. Full stop. Next para, such written notes of arguments shall also be filed along with oral arguments on the returnable date. Full stop. The matter shall be taken up for hearing at 10:30 a.m. on July 15, 2024.
Very great. This application may be disposed
of. Yes. This GA Com 7 of 2024 is accordingly disposed of in the light of the above observations.
Great.
Item number 17, Titagarh Rail Systems Limited.
Section 34 applications. I award primarily in my favor. I have only challenged a portion which has not gone in my favor. And he has obviously challenged the principal award.
Both have challenged.
Both have challenged. His is part, mine is full, which is why I wanted to stand with the petitioner supposed to. Because if I
then my matter is first.
No, Mr. Bose, if he challenges, wins in his challenge, then
This is anyways.
yours become
Also maintainability, whether part modification can be short by over 34.
I am not sort of modification, I have
So
sort
this
of.
is correct. So part challenge
He's aggrieved by a part of the award.
which I'll
I had
probably
a-
be able to show that it's not maintainable unless it's severable, and his case is not that it's severable.
No, I had an application.
Whatever.
I also
So
had a
that
prayer under
we
section
have to fight
34,
on that.
which Justice
Either way.
Bhattacharya was-
So when can you come back with your half-hour preparation?
40 minutes, 40 minutes. 40 minutes. The plus minus
No.
5 makes it plus
I'll make it plus minus 10.
10 plus minus 10.
It can be minus also.
Huh?
Minus, I'll award brownie points if it's minus. Like the Arbitration Act, in fact. If it is done in 6 months, then you don't get money from me. But I'll make it 30 plus minus 10.
But a slightly longer time than
What is the point?
there's an agreement by which wagons are to be. Lord, essentially, if damages can be awarded where I have gone ahead and made supplies contrary to a contract, where the evidence is unequivocally clear that they don't manufacture. I have manufactured. There's certain royalty that they are supposed to be entitled to under the agreement. That they have received that royalty even post a certain cutoff date, that's also admitted. They've been awarded damages for manufacture of wagons as if what they would have earned had they manufactured. With specific, they stand on evidence is that they don't manufacture. So I'll just show essentially on perversity that damages has been granted contrary to.
And what will be your...
My case was, I lent him a design. I licensed to him a design which he was supposed to use for a particular period. My case is that the period came to an end. He ought not to have used the license after that, the design after that, he has used. So my case was for a perpetual injunction, which I have got, and a claim under section 40 for damages in addition to injunction because of wrongful use of a design of which I am the proprietor. Now, what my learned friend says, the arbitrator has taken a measure as a measure of damages, the profit that they have earned as a result of the wrongful use of the design, and said that by wrongful use of the design, if you've earned this much profit, that is what you have to pay. Whether I manufacture it or not has no relevance, because this is not a case under section 73 of the Contract Act. It's a case under section 40 of the specific.
This will go from his 10 minutes. His
No,
per time
no,
that he's
then
awarded is
whatever
asked.
you have said also goes from your 10 minutes.
His 10 minutes. He'll come back now.
Kindly, Millet fixes it.
Learned counsel for the parties indicate in a nutshell the contours of their arguments in connection with the competing challenges under section 34 of the Arbitration and Conciliation Act 1996, full stop. Upon such preliminary hearing, the matter is fixed for hearing at 10:30 a.m. on July 16, 2024, full stop. It is made clear that each side will be allotted 40 minutes within bracket plus minus 5 bracket closed for advancing their oral arguments as well as file their written arguments simultaneously. Full stop. The copies of the written notes of arguments shall be exchanged between the parties sufficiently in advance before the next returnable date. You can have a joint conference and make your notes of argument. Yes. You take this one, I take this one, and yes.
Okay.
If I start this practice, Mr. Banerjee, if it catches on,
it will be much
it will be easier for the advocates also, because you get to know that I get this much time and your preparation will be much better.
No, there are two things. One, I know that this is the time I get, and I know that this matter will be heard on this day.
Yes.
Both are equally important.
Hugely advantage.
Right. Therefore, because I can take up other matters also.
Yes.
Very good.
Item number 19, Sajarul Rahman and another.
Before item number 19, Lordship takes up, item number
17, 10:30 is free for you.
No, I'll come to that, my lord. Item number 6, which was there in the morning,
yes.
Lordship, my lord, they have placed certain judgments. My lord, although I find that Lordship has expressed that those judgments do not, my lord, apply. But still then, my lord, I need to deal with them. Lordship has kept it, reserved it for order, so I should get a chance, my lord, to deal with the judgments. That's MSME matter, my lord, with regard
The
to the
judgments were on what? I mean,
they're not maintainable at all. So, my lord,
what are the judgments on?
they are on section 34, but he's not there. I shouldn't make submissions, my lord. Section 34 judgments, my lord, are not, my lord, to be looked into in a, my lord, proceeding under section 36. And lordship has already held yesterday in a judgment also that in 36. So that's why, my lord, I have to.
No, Mr. Banerjee, I have closed arguments.
But
Your learned
my
junior
lord,
was present.
yes, he has asked for 5 minutes time. Lordship has said that I will. But that would be, my lord, something which would prejudice my client. Yesterday I was there, he was not there. I never opposed. He took an adjournment.
Your other side is here now.
I will inform him, Sharbhupra.
Inform him. Oh, Sharbhupra Mukherjee.
I will inform.
Inform him tomorrow at
I'll
it will
take
appear
only
under the
5
heading to be
minutes,
mentioned.
5 minutes I'll
Appear
take.
under the heading to be
5
mentioned. ওইটা আজকের অর্ডারটা ওপেন কোর্ট কালকে দিয়ে
I will
to be mentioned. It will come up as to be mentioned. I'll clarify that on mentioning I'm taking it up. I'm taking it up again and
Yes.
just give
Now,
notice to Mr. Mukherjee. You
I
take
will,
your 5
I will
minutes to
personally
reply.
talk to him, my lord. I will, my lord. My lord, item numbers 19 to 27. My lord, this relates to a little serious issue with regard to section 34 applications being filed in this court and across West Bengal. My lord, this, my lord, relates to, my lord, I have taken the point of maintainability of all these proceedings, my lord, not to be maintainable before this court, my lord, because there is a stamp duty which is, or court fee which has to be paid of 5,000 rupees. Now, from this amendment has come in 2002 first. My lord, there was a matter which had taken place, my lord, in this High Court, taken over by, my lord, Honorable Justice, then Honorable Justice Indira Banerjee, where a sympathetic note in the judgment was made that, my lord, since, my lord, a proceeding of a suit is filed by 50,000 rupees, my lord, court fees. Therefore, my lord, although the Court Fees Act at that point of time in 2002 said that, my lord, the arbitration award over 50,000 rupees is to be filed either by rupees 5,000 or, my lord, 1.5% of the whichever is greater. Now, my lord, in view of that, my lord, the consultation was made and the legislator thereafter, my lord, had come up with, my lord, amendment in 2006, whereby a flat rate of 5,000 rupees court fee was fixed for all section 34 applications. Now, my lord, the matter was taken up on several occasions earlier. We were not able to find out the date on which this notification came into effect. Now, my lord, Mr. Mukherjee, as he then was the Advocate General, was informed, and after much, my lord, searches, if I may say, my lord, he was able to find out the notification date that it's around October, my lord, 2006. So, my lord, now the amendment was that 5,000 rupees for a court fee is to be paid before an application is taken on record, my lord, of section 34's, my lord, before any court in West Bengal. Now, my lord, admittedly, although, my lord, I found out that other courts in West Bengal had been taken it in Calcutta High Court, my lord, it is filed with 120 rupees or 130 rupees. So there's a huge exchequer of the state government which has been flouted in view of this action. And, my lord, there is also this, I would put it like a scam, my lord. How it is filed, I don't know. Now, the question is that here, which is very relevant, is that there is a right which accrues, my lord, after 120 days is passed. Because, my lord, the person who is filing a section 34 is not entitled to file, and the court also becomes, my lord, non-judice, my lord, because, my lord, he will not be having the, my lord, jurisdiction to even extend the time.
So, with a subsequent satisfaction of deficit court fee, that can relate back to the date
Yes. Now, my lord, the question is that, my lord, in all these matters, therefore, my lord, what has happened is that they have filed it, my lord, this is 2006 and we are in 2024. So almost 20 years close to have passed. Now, my lord, they have filed it, my lord, saying that we were not aware. But, my lord, negligence or, my lord, ignorance of law cannot be a ground or a defense in such commercial proceedings. Second,
and the other question will be whether it can be cured. It's a curable defense.
Yes, of course, my lord. I'll show that it's not a curable defense.
Yes.
Thirdly, my lord, is that, my lord, the question is that, my lord, even if they pay a deficit court fee and file it, my lord, whether they can, my lord, thereafter cure it, my lord, by, my lord, the court accepting the fact that very well they have filed it, the deficit court fee can be paid. But this period, by this period, if 120 days have, my lord, elapsed, my lord, whether that order can even be passed by the court. Because My lord, we are all aware of section 149, my lord. 149 now has become very rigid, my lord. It does not say, my lord, as a matter of right, court will, my lord, extend the time. My lord, one has to satisfy.
No,
My
no.
lord, with regard
If
to
it
suits.
if it is held that it relates back to the date of the filing,
Yes.
then this problem will be alleviated, mitigated. If it is held, it cannot relate back, then only this question will come.
It
So
cannot,
that is
it cannot relate back because my lord, this is a amendment which has taken place in 2006, which is coming
yes,
to effect.
yes.
These are proceedings all filed in 2023.
Hmm.
So therefore, my lord, first of all, there is no question of saying that I was not aware of
No,
this
relate
amendment.
back means relates if deficit court fee, if it's a curable defect,
But I will demonstrate that it is not a curable defect.
if you fail to demonstrate that theoretically, Mr. Banerjee,
Then, my lord,
then the rest follows.
Then the rest
then
follows.
the other questions do not come in.
Absolutely.
If you succeed in saying that it does not go back, then you have a very good case on limitation. I mean, it's
earlier
almost
there
a
was-
complete bar now.
Earlier there was a little sympathy, my lord, of the court, which I understand what happens to all these litigants over the years. But my lord, somebody has not pointed it out, does not mean that, my lord, the others will get benefit of it when there is a legislation. Then would apply to all legislations, my lord, and my lord, the amendment will never come into effect. That cannot be the law. So, my lord, it has to go, it will go, because here there is, my lord, unlike suits, here, my lord, there is a right which is, my lord, accruing if it is not filed within 120 days, because I can file an execution there and there itself. Because it's a time-bound effect. And my lord, 120 days is very rigid. Because all Supreme Court judgment says post 120 days court does not have.
So,
my lord,
Banerjee,
any-
you have to keep in your mind, I'm giving you advance. I mean, because if you also have to keep in your mind the combined effect of sections 33 and 35 of the Stamp Act, the principle flowing therefrom. Now, if it's a waivable right,
It is not.
It cannot be an absolute right
It is
unless it is taken at the first at the
because
inception.
why I'll say, my lord, I'll
Deficit
show
stamp
from the-
duty, the deficit stamp duty cannot be taken later on. 36 is there, 34, 35, 36. So if it's a waivable right, then it cannot be an absolute right, absolute bar.
But it is not a waivable right. Why I say so? Because, my lord, I'll show the statute, and it has been held in several judgments also, that, my lord, there is no section 34 application unless, my lord, the stamp duty is paid in full or the court fees is paid in full.
That is only what you have to show.
So if I can satisfy that from the statute, then, my lord, even a person who files a deficit court fees application, and, my lord, he comes before the court, my lord,
The
for that
court
order.
becomes functus, not even functus officio, functus officio
Quorum
ab
non
initio,
juris.
quorum non juris, quorum non juris.
So it
That's a
does
very
not
strong
have-
argument then.
Exactly.
If it's an honest, if it's an honest application under section 34 for non-payment of full court fee, then you have a very good case, as I told you.
Because that's the language in the statute itself, which is been held also. And I'll show, my lord, this issue has been also dealt with
Which
by.
section is that?
Or kindly take section 4 of the Court Fees Act. Once, my lord, kindly sees the language. And I'll show from prior amendment till
Exactly.
date.
Not
My
there,
lord,
I'll check up.
I'll just hand over, my lord. I'll just show it to my lord. Lord, it says,
Yes.
no document which is chargeable with fee under this act, or kindly sees now, be filed. So the word is filed. Be filed, exhibited, or recorded, or be acted on or furnished by any court, including the High Court. So, my lord, therefore, be filed, my lord, means from the first itself that no document can be taken on record without the chargeable fees being satisfied. And, my lord,
Language is very harsh.
Very harsh. And, my lord, I'll show, my lord, this has been dealt by this Honorable High Court, wherein, my lord, it has been said that the statute has to
How
be
do you deal
followed
with
in total.
2, Code 2, subsection 2?
Yes. My lord, kindly sees, my lord, be filed, exhibited, or recorded in public office to be acted on or
B.
furnished.
Not B. Section
The
4,
only-
subsection 2.
Yes, my lord, notwithstanding anything contained in subsection 1 or any other act, a court may receive a plaint or memorandum of appeal in respect of which an insufficient fee. So, my lord, they have been very categorized. Legislative intent is very clear. This is, my lord, a special statute. Section 34, otherwise, my lord, would open a floodgate. If, my lord, I pay a deficit court fee and, my lord, keep it pending and come after 2 years and say, my lord, I paid a deficit court fee, kindly extends it.
A suit and a regular suit and a regular appeal can be filed
regular appeal and suit can be filed. I'll show that page. That is section 149. That is section 149. But here, my lord, that is not so. Because, my lord, the terminable date is 120 days. Thereafter, court becomes completely, my lord, functus officio, or rather, my lord, quorum non judice. That's the distinction, my lord. So I'll show, my lord. I'll show it, my lord.
We'll try and dispel those submissions. Yes, definitely. Let us come back tomorrow then.
Tomorrow at 10:30, my lord.
No, not this matter.
Otherwise, what happens, my lord? We all get ready in this matter, and then it's never any day lordship fixes, my lord.
But then I'll have to give a timeline.
Yes, yes, of course. I'm ready with the matter, my lord.
So, how short can you be? I mean,
My lord, I will take, my lord, 45 minutes. My lord.
so 45 to each of you.
Yes.
Fair enough. आज को हाँ? No.
No, not tomorrow.
Some
Lordship
other day.
keeps it-
Tomorrow is fixed for first the judgment, the examination of judgment debtors. That is. So today we are on 3rd. I'll keep it on 10th. Next Wednesday.
May it be, my lord, after 15th.
After 15th?
Yes. Any day, my lord, at 10:30 after 15th.
17th কোনো ফিক্স করলাম হ্যাঁ একটা 16 17th দুটো বোধহয় ফিক্স করলাম 16th 17th না 15 16th করেছি তাহলে 17th করছি এটা
But I think lordship fix one also on 17th, my lord.
Yes, I was wondering.
Maybe on 18th, lordship at 10:30 and come.
18th no 18th is examination of judgment debtors first. 19th is appellate set first because one day
Any other day.
Then it has to be the week after that. I'll keep it the next Monday.
Yes.
22nd July.
Yes.
Very well. Upon a preliminary hearing of learned counsel for the parties, comma, the matter is fixed for being taken up at 10:30 a.m. on July 22, 2024 for hearing, comma, subject to the rider that each side will be allotted 45 minutes for making their oral arguments, who simultaneously, comma, both sides shall file their written notes of arguments upon prior exchange of affidavits, exchange of written notes of arguments
Only
sufficiently.
one thing, if I may just pray in this matter, my lord, I do not know what extent I have to argue. So notes if we file it after the argument, my lord.
Very well.
In this, my lord, I have to, my lord,
Very
there may
well.
be a lot of questions from my lord also.
Very well. Right, maybe. So, 45 minutes for advancing their oral arguments. Full stop. This much.
45 minutes, my lord, to each of the petitioners, my lord, because there are several petitioners. The
petitioners
respondent
are
is common.
Have a joint conference, make a common points. Make a common list of points. No.
But give us half an hour each, my lord.
No, choose one of you among us.
For different matters, but
Different matters, principle
Point
is
is
the
the
same.
same, yes.
Point is the same.
half an hour each to,
No, definitely. No. How many of you are there?
No. No,
Who?
no. There are,
Who
my
are
lord,
coming before me now?
I am for 5 matters, so I take care of 5 matters.
How many counsel? Have a joint sitting. Whoever is senior, you place your arguments. If he misses out something, the other person argues. But it will be 45 minutes.
my lordship.
20 minutes each, I think that will also surprise me. Well, let the
Not
first
to
speaker,
each is very open ended.
let the first speaker get 30 minutes and the others get 15 each.
No, that you decide among yourselves, but the total time is 45. You will have to adjust among yourselves. You can distribute points like in a debate.
Parliamentary style debate.
Parliamentary style. You can distribute between points, between different points, or one can argue and the other will supply the missing points. But the total time is 45. I cannot manage matters otherwise.
My lord,
Have a joint conference between yourselves. This will create a bonhomie among the bar also, and you can have tea, exchange refreshments.
Only this much.
Whoever is there, all of you are from this court only.
Yes.
No outside counsel. No, then you can have, I mean, not for any other reason, because then you can have a common conference or something like that. But evolve some measure, but it has to be 45 minutes total.
I break with the time amongst
No. 45 minutes, I'll keep a bell, alarm bell, a stopwatch.
the only thing is that, my lord, there has to be separate orders, my lord. Each same order, my lord, in separate matters from 19 to 27, because the petitioners are all different. Respondent is common.
There will be a common set of arguments.
No, I'm not on today. This order, my lord, has to be separate, my lord. That's what.
No, I'll add a line that in view of common issues being involved, the pratham line, it is bolam tar age common at a line at. In view of the issues involved in all these matters being common, comma, the matters are being taken up together for hearing. Then whatever is it.
My lord, I'll inform Mr. Mukherjee for tomorrow's matter, my lord.
Which Mr. Mukherjee?
For Gopriya, my lord, for
Oh, the other matter, yes.
I'll inform.
Division. Item number 1 to be mentioned, State of West Bengal versus Shambhunath Ghosh and
I do not know.
But we have mentioned this matter, my lord, upon notice. This is a 34 by the state. My lord, the award has been passed, my lord, in 2010, my lord. I am a 90-year-old man, my lord. And till date, my lord, after getting a stay on the award, they are not, my lord, proceeding with the 34. 34, my lord, is pending. I have done this work, my lord, in 1994. And, my lord, till date, my lord, I have not enjoyed, my lord, the fruits of the decree.
What is your age, you said?
90.
90.
90.
Lordship, this is an under the old Act, 1940 Act.
Oh.
So it's not 34 and it's an automatic stay. See, the law was with regard to once you file it, it's an automatic stay. And more than that,
No, no, there was a
here,
particular order of
here what had happened, a decree was passed in terms of the award under the old Act. The decree was recalled upon we depositing the entire award. Entire amount has been deposited. So we are already out of pocket. The deposit is being deposited.
But they cannot take it.
Yes, they cannot, because under the law was that I do not have any.
So I'll fix it sometime next.
But even if it is under the old act, the test, my lord, is very clear.
No. Test is remains the same. Let's not confuse.
Then it's all the
law.
I'll be
police.
going to take the Jalpaiguri bend. I'll fix it after that. I'll fix it on today. I'll fix it on 6th of August at 10:30. I'll allot half an hour to each of you. I'll put that in my order and file a written note
Lordship,
first.
one more thing, I do not have any difficulty with the dates. Second, there is one difficulty which I have been told, the affidavit in reply hour,
We have reconstructed. No?
we have to reconstruct it because it's not there. That's one part. And second, I'll require leave from your lordship because they are voluminous documents. What I could find in 15 minutes time, the brief was given 15 minutes back, I could find all documents are not here. So I will require a leave to file a informal paper book annexing all the documents which were before the tribunal.
Leave is granted to learned counsel for the parties to reconstruct the misplaced documents, in particular the affidavit in reply of the appellant. Full stop. Next para. Learned counsel for the applicant is also granted leave to prepare informal paper books before the next returnable date and exchange copies of the same with its counterpart appearing for the respondents. Full stop. The matter shall be placed in the list on August 6, 2024 for hearing at 10:30 a.m. Full stop. Learned counsel for each of the parties shall be allotted 30 minutes for completing their oral arguments. Full stop. Learned counsel shall also exchange written notes of arguments in the meantime and file the same on the next returnable date. Thank you.
My lord, they should, my lord, serve a copy of the paper book, my lord, well in advance, at least, my lord.
Yes, do that, please.
I have to also get ready after.
Otherwise, a day before, my lord, the state will say.
No, do it.
I'm told that the reconstruction has been done.
Briefs, my lord, are already ready. This is the opposition and the reply.
The reconstructed opposition and reply file today be kept on record. Thank you. Acha, Pradut Babu. Yes, Mr. Banerjee, who was appearing?
Please, I can inform them, Mr. Medora and Mr.
Please inform either of the two. It will appear as two mentioned tomorrow. I'll fix another date. I forgot that I'll be out of town. I'll be in Jalpaiguri bench from 22nd for 2 weeks. So I'll fix it on.
Kindly, my lord, have that 17 date, my lord. I think that is vacant, my lord. 17th lordship is not.
17th, I'll keep it on that date.
Yes.
Yes. But subject to the parties being notified, I passed an order in open court fixing it on some other day on 22nd. I'll
will
put it as
inform
to be mentioned tomorrow. Please ask them to. Thank you very much.
She will not put any other matter on 17th then.
No, today. Yes, you're right. Thank you very much. Right. Thank you.
17th, my lord, again is a holiday.
I'll then keep it up sometime after I come back. I mean, August first week.
Kindly fixes it, keeps it tomorrow as to be mentioned.
To be mentioned, it will appear tomorrow as to be mentioned. I'll see the convenience of both parties. 17th share holiday. Tomorrow.
Item number 2,
Yes.
examination of judgment letters, EC 22.
I appear for the judgment letter.
Judgment letter is present.
Judgment letter is present. Only thing is that your lordship had directed me to file the affidavit of asset by Friday. I couldn't make it ready. I have made it ready now, lordship.
But then how can he be examined? He also sought time to explore alternative avenues to meet the award. You have failed.
Lordship, that is there also.
But if you are filing the affidavit of asset right now, how can they examine
I
you?
understand, your lordship. Kindly grant me another date. My judgment letter is present today also. He'll remain present. Then
I'll do that next Thursday. Learned counsel for the award debtor files the affidavit of asset. Full stop. The delay in filing the same is condoned and the same is accepted. Full stop. You have given a copy to her.
yes, I'm giving
A copy of the same is also handed over to learned counsel for the award holder. Full stop. Next para. The judgment debtor is present in court and shall again be present when the matter is called up on the next returnable date. Called on the next returnable date. Full stop. The matter shall next be listed under the same heading for being taken up at 2 p.m. on July 4. July. No,
no.
Calcutta. Come back tomorrow. You can come back tomorrow with tomorrow, that is on July 4, 2024.
Yeah.
Right.
Thank you.
Thank you. New motion, item number 3. Kishore Himat.
Please, my lords, I appear on behalf of my lords, the petitioner.
The petitioner, I'm led by Mr. Prathamesh Kamath, my lord.
Yes, Mr. Kamath.
My lords, this is an application, my lords. If my lords, if I may take my lords to the prayers at page 25 to 27, my lords, seeking my lords inquiry under 340 of CRPC for perjury, my lords, for making false and incorrect statements, my lords, on oath, as well as my lords for my lords fabricating documents. My lords, may I invite my lords' attention, my lords, this fabrication, or rather these false statements stem from my lords, a section 11 application that was filed in your lordship's court. May I invite my lord's attention to page 36.
36?
Page 36, my lords, volume 1, page 36.
Yes.
Section 11 of the Arbitration Act, application for appointment, my lords, of an arbitrator. And I will, my lords, demonstrate, my lords, how statements were blatantly false statements were made, my lords.
Give me half a minute, Mr. Kamath. CRPC, IPC, duty and IPC.
For my lord's assistance, certain provisions of the CRPC has also been quoted in the petition, which is at page 20.
Right. Thank you so much. Mr. Kamath, please continue. I'm sorry.
Page
36, yes. 11,
yes,
section
page
11.
36 is section 11 where it starts. My lords, let me straight take my lords to the false statements in the 3 paragraphs of section 11. Your lordships will find that at para 5, which is at bottom of page 38.
Right, yes.
Subsequently, on consideration of respondent's request for loan cum hypothecation agreement dated 30th June 2018, bearing agreement number so-and-so was entered into by and between your petitioner and respondents herein, whereby the petitioner has provided financial assistance to the respondent for acquiring assets as required by the respondents. Please note, my lords, the language under the said loan cum hypothecation agreement dated 30th of June 2018, agreement number so-and-so. The loan cum hypothecation agreement of June 30, 2018, wherein number so and so was signed by the respondent at the regional office. My lords, then thereafter, my lords, that continues. May I then invite my lord's attention to para 6. Consequently, the respondent took possession of the assets, being several assets, being one of them being the names of the vehicles, my lords, are mentioned in para 6.
Yes.
Then, my lord, para 7, the petitioner provided a financial facility for rupees 6 crores 37 lakhs 34,886 to the respondents. Please mark the words, my lords, what they say: under the loan cum hypothecation agreement dated June 30, 2018.
Yes.
Agreement number so and so. So it is effectively their case that a loan has been disbursed under this agreement of 2018, and where, my lords, for purchase of these vehicles, which are mentioned in para 6. Then, my lords, para 8, the last one to trouble, my lords, the court. The respondent under the said agreement was required to pay the petitioner along with the agreed interest, aggregating to 6 crores 92 lakhs 59,319, which was to be repaid by way of 58 monthly installments in acknowledgement of the said loan cum hypothecation agreement. Please note, dated June 30, 2018, bearing agreement number so and so. Respondent has made payments till 22nd monthly installments under the said agreement, and thereafter has failed and neglected to make further payments of the said monthly installments to your petitioner as stipulated under the agreement. It is stated that the said payments were made beyond their respective due dates, etc. So, my lords, their case is that under the 2018 agreement, my lords, there were 22 installments were paid, balance not paid, and my lords, therefore, on this basis, my lords, of course, there are, my lord, legal notices. I am presently not troubling you, on the basis of which, my lords, an arbitrator was sought to be appointed. Your lordships will find the prayers of section 11 at para 30, page 46.
Right.
Your lordships will find, therefore, in, my lords, in the first.
So, Mr. Kamath, your thrust is loan cum hypothecation.
No, my thrust is, my lords, it has been, my lords, in their case, they sought an appointment of an arbitrator under the 2018 agreement for loan, according to them, of disbursement being made under the 2018 agreement, which, my lords, they have, which has been their case all throughout until, my lord, even on affidavit before your lordships court in section 11 petition. Now, my lords, this statement has been, is demonstrably false basis their own case, because in the before the arbitral tribunal, they have now filed an amendment application where they concede, or rather now they've made an application for amendment where they say that no disbursement has been made under the 2018 agreement, and that is very absolutely categorical.
Have you annexed that amendment application, Mr.
Yes,
Kamath?
my lords, I have. The lordships will find the amendment application at page 188. That is volume 2.
Yes. I'll just come to the schedule of the amendment.
Yes, please. My lords, what they've done, my lords, is they filed a proposed statement of claim. 188 is the amendment application, but what they've done, instead of schedule, they've filed a proposed statement of claim in form of their schedule.
Show me the altered paragraphs.
Yes, my lords. It starts, my lords, just to give the code, the page numbers at 197.
197, right.
And my lords, your lordships will find at
page 199 onwards is
onwards, they've struck off 5, 6, 7, 8. Your lordships will find 5, 6, then 7 and 8 being struck off. This exactly has been, my lords, the case before your lordships court, as I've just read out.
Yes.
And then, my lords, your lordships will find a categoric statement that under just 200. Sorry, your lordships will find then at para 20 at page 207. Just show me that. At page 207, my lords, where they say your claimant states that from the aforesaid facts and circumstances, it is clear that under the instant agreement dated 30th June 2018, bearing number so and so, there was no disbursement of any funds. Only liabilities of the previous agreements were restructured in the instant agreement as per the respondent's request. It is further pertinent to mention that the respondent has acted in terms of the instant agreement dated 30th of June 2018, bearing agreement number so and so, by paying 22 installments. The repayment of the repayment agreement dated 30th June 2018, bearing number so and so, will be evident from the statement of accounts maintained. So now, my lords, there is a complete volte-face in terms of, my lords, disbursements being made under the 2018 agreement, because that has been their case consistently. We've seen those 3 paragraphs. Now their case is that there is no, my lords, disbursement under the 2018 agreement. My lord, things don't stop there. May I invite my lord's attention? And this is this becomes even more interesting when we, my lords, the agreement, the 2018 agreement, your lordships will find at it first volume, my lords, page 49. This, my lords, your lordships will find, of course, it mentions 30th of June 2028, but let's take, this is the 2018 agreement. This has been captured in the order of order of your lordships court appointing the arbitrator as well. What is interesting in this is, my lords, so just, my lords, to leave no room of doubt to suggest that, oh no, this is an error, this might be an error, this is a type, this must be some mistake. Please see, my lords, the document at page 79. This is the schedule to the loan agreement. In the schedule to the loan agreement, my lords, at page 79, your lordships will find, my lords, these annexure details will mention the assets that are, my lords, the type of the assets, those vehicles that they say are under the 2018 agreement. When there was no disbursement made, when it is their case that vehicles were financed under a now as per the amendment, their case is that, oh no, that was under the under a completely different agreement, which is your 2011, 12, 13 agreements. So therefore, this document will demonstrate, I mean, this document clearly, my lords, is a fabrication, because now, as per your own case, there was no disbursement under the 2018 agreement. There's no question of assets being acquired under this agreement. Their case being categoric that the assets were to be acquired under a completely different agreement. My lords, my lords, these are some of the things, my lord, I must just point out for the sake of completeness, my lords, page 105, volume 1, the order of your lordship's court, Justice Bhattacharya's order, making, my lords, where arbitrator was appointed. Basis these, my lords, basis this contention or basis the averments in section 11. Of course, the only opposition there was, which is recorded in page 106. But this was a application under 11 read with section 14, because your lordships are aware, my lords, after the 2015 amendment to the Arbitration Act, unilateral appointment of arbitrators, my lords, is now gone. We are now governed, my lords, especially, my lords, in light of 12.5 read with the 5th and the 7th schedule of the Arbitration Act. So, my lord, there was an arbitrator appointed. This was their case before the arbitral tribunal. This was their case before your lordship's court in section 11 read with section 14. This has been their case in, my lords, in the demand notices, in the legal notices. And, my lords, therefore, my lords, which culminates into the 11 read with 14 application in your before your lordships. Of course, now there is a volte-face, and now, of course, and rightly so, they've made, because, my lords, we filed a written statement before the arbitrator demonstrating that there is no payment, no disbursement. In fact, there is, in fact, a no due certificate, my lords, that should demonstrate. In fact, my lord, showing that there is no outstanding under the 2018 agreement. In fact, my lords, criminal cases which were filed basis the outstanding under the 2018 agreement were expressly withdrawn. But, my lords, since I'm in perjury, my lords, the application presently is, my lords, is a 340 application. My lords, I am conscious that I will have to, my lords, demonstrate, my lords, false statements and fabrication, my lords, if any, prima facie for the court, my lords, to then, my lords, direct a complaint to be registered, my lords, before the competent court, and, my lords, who thereafter, my lord, just one thing, of course, your lordship knows the proposition, so that the court may just make a note, my lords. This is I am here to satisfy what, my lords, if the any queries from the court. But at this stage of the proceedings, my lords, the person against whom, my lords, perjury, my lords, has been, my lords, allegations of perjuries have been leveled, have, my lords, as your lordships are aware, no right of audience. My lords, I'll just give a citation if need be, my lords, for that purpose.
Regarding right of audience?
They say that, my lords, they need not be heard. That's what, my lord, the Supreme Court says in Pritish versus State of Maharashtra.
Mr. Kamath, the established position of law is that they don't have a right of hearing, but the court is not precluded in any.
No, of course not. I'm sorry, my lords. I should not be misunderstood. If the court wants, most certainly.
Only then. Only then.
The court. There is no embargo on the court. And there cannot be, my lords, it is ultimately your lordship's conscience needs to be satisfied. And my lords, that is precisely
But
the
first,
reason.
Mr. Kamath, satisfy me. Why is it expedient in the interest of justice? That is the language of 340 for this. Yes, there is a volte-face, no doubt about that. There is a complete contrary, a paradigm shift from their original pleadings. But why should that be elevated to the plane where it would be deemed to be a perjury? Because two aspects are there.
My
One
lord.
is that the order of Justice Bhattacharya, which referred the matter to arbitrator and appointed an arbitrator,
yes, my lord.
Nothing hinged on these the dates or the different agreements on the variance of pleadings. Nothing hinged on that.
The variance of pleadings happened later. That is why, my lords, it never the order.
Right. No, I mean to say I could not express myself properly. Probably nothing would have hinged on this. Suppose because that was not a consideration at all. Even if it was as it is now, there are new pleadings. Even if that was so, the points on which the objection which was taken and the point on which this was referred, I mean, it's an administrative job under Section 11, basically now. We have to satisfy ourselves. There's an arbitration clause and all these things. So you say it's a different agreement altogether. That's why.
The different agreement altogether. My lords, a party was dragged into arbitration, or now rather dragged into the arbitration. Of course, where, my lords, a party will take whatever defenses as are available.
You have to. Yes.
Yes. But, my lords, in addition to that, my lords, unabashedly, my lords, a statement has been made, my lords, a false statement has been made to persuade a court to appoint an arbitrator under an agreement under which there are no disputes pending. But this, ultimately, the ages of the courts have been utilized for appointment of an arbitrator. Rather, a party is forced to litigate under, my lords, an agreement where there is apparently no my lords, dispute, or, my lords, there cannot be any disputes if there is no my lords, this is not something that, my lords, a solitary statement that has been made for the first time where we can understand, my lords, that there really my lords needs there can be an explanation form of a mistake. But if there this stand has been consistent throughout, that's why, my lords, I indicated, my lords, if need be, I'll take the court, my lords, through the statement of claim filed before the erstwhile arbitrator, my lords, whose mandate was terminated by this order. My lords, in form of legal notices, in form of the application under Section 11, because, my lords, all courts at all points, or quasi-judicial proceedings, or, my lord, before the arbitral tribunal or before your lordship's court, a stand categorically taken that there is, of course, there is an outstanding under this agreement. We have made disbursement under this agreement. But now, please look
Mr. Kamath, your relief lies in taking an objection to the amendment application. The amendment has been allowed by the arbitrator.
Not yet, my lords. They have.
Your remedy lies there. You can take out an objection, obviously, because the entire premise of the assumption of jurisdiction of the arbitrator may be. I mean, I need not advise you. You know better.
No, my lords. I understand.
Yes,
I
because.
understand.
But how does it amount to perjury? I mean, they say they relied on a particular document. They still don't say that that document does not exist. What they say now is that there is such a document of that date of 2018, but that is only a restructuring of the previous 2011 whatever agreement was there. So they do not try to obliterate or efface that document from the face of earth. They say that document is a mere restructure. They want to change the complexion of that document before the court. Now that has to be dealt with by the arbitrator, even the assumption of jurisdiction.
Certainly, yes.
And Section 16, Section 16 is there, competence principle is there.
Well, the point that the reason to answer the court's question, and I really
want
to, my lords, straight away answer the court's question is, my lords, these are statements made on affidavit. This is a stand taken by the person on affidavit claiming, and please see, my lords, the verification clause, my lord, this is not something that, my lords, which has innocuously crept, or, my lords, inadvertently crept in. This is something that has been deliberately stated, and please see the consequences of, my lords, of volte-face. My lords, a party comes to look at it from a slightly different angle. A party can therefore come to your lordship's court, say anything that he wants on affidavit, get reliefs allowed, and then, my lords, go and completely, my lords, change his stand, go turn volte-face, and, my lords, make out a complete. But the whole sanctity of, my lords, stating things on affidavit, my lords, it puts, my lords, the entire jurisprudence of, my lords, of hurting the sanctity of putting things, my lords, on affidavit, my lords, in peril. Please see, my lords, the affidavit, or rather the verification clause or the affidavit at page 48 for a moment. This is not, my lord, something that termed as so innocuous. Please see, this is the affidavit, my lords. In various other courts, my lords, we file in form of verification. Here it's filed in form of an affidavit. In the lord's court.
Yes.
Please see what he says. This, my lord, this is a man who, a son of so and so. He's the legal manager, so he understands, my lord, what he speaks in terms of in the terms of language of law. I am the and, my lords, the second para. Statement contained in paragraph numbers 1 to 8 to the foregoing are true to my knowledge and matter of record, and those contained in so and so as submissions before this court. He bifurcates, my lord, he makes it very clear of his understanding. My lord, he's not, my lords, some, my lords, manager from some loan department who does not understand, my lords, what is what. He has, my lord's, formal understanding of law.
Mr. Kamath, please once more come back to page 207.
My lord, please.
Please come back to page 207, para 20.
Yes, my lords.
Now that paragraph is still retained in their pleadings.
My lord, this paragraph is my lord, sought to be introduced.
But please read it out. I mean, it
Lord.
retains on two important aspects. It remains the same. Their stand remains the same, that there was an
On the
agreement.
existence of the 2018, I understand.
Existence of that agreement, and not only
agreement.
that, payment of 22 monthly installments in terms of the repayment schedule of that agreement. What
But
they
just-
want to do is to change the character, try to change it takes a different character now. It's a restructuring of previous loans. Now
Right,
they
that-
want put in a narrative of previous facts.
Correct. What really is important in fact in para 20, apart from, my lords, now attempting to, my lords, completely renege, attempting to, my lords, to renege from what they have stated in paragraphs 5, 6 and 8, and that is why, my lords, they sought to obliterate that completely. But in para 20, apart from, my lords, making a statement which is not merely, my lords, in that sense, completely mutually destructive, as the court, my lords, puts it to me rightly.
Not
So it
that,
is mutually
not mutually exclusive.
No, mutually destructive in form, because here they say no disbursement. Their cases, there is disbursement.
No, in para 20, they're saying by paying 22 monthly installments.
No,
It
I'm
was
sorry.
this.
Look, I'm sorry, I did not express myself clearly. My lords, the first 4 lines of para 20 states
Yes.
clear that under the instant agreement that is of the 30th June 2018,
Right.
there is no disbursement of any funds, which in fact has been the
Please
fulcrum of
read the entire sentence, Mr. Kamath. Once let us read it together. The
Yes,
page
my lords.
para
May I
20.
read for the
The
court?
entire paragraph, please.
Yes, I'll read the entire paragraph.
Yes,
Your
yes.
claimant states, from the aforesaid facts and circumstances, it is clear that under the instant agreement dated 30th June 2018, bearing agreement number so and so, there was no disbursement of any funds. Only the liabilities of the previous agreement were restructured in the instant agreement as per the respondent's request. It is further pertinent to mention that the respondent has acted in terms of the instant agreement dated 30th June 2018, bearing agreement dated agreement number so and so, by paying 22 monthly installment in terms of the repayment schedule of the agreement dated 30th June 2018, bearing agreement number so and so, which shall be evident from the statement of account maintained by the claimant company. A copy of the statement of account maintained by the claimant company.
So they still say that they have paid 22 monthly installments in terms of the now they label it as repayment schedule of the agreement dated 30th June. They still make the payments in terms of 2018 agreement, but it's a repayment schedule in a new avatar now, and the new avatar is the same document.
But just two things, if I may proffer for the court consideration.
Please,
My lord,
please.
if my lords, as they say, that this is these 22 installments, and my lords, keeping in mind that there is no disbursement under the 2018 agreement, that is why, my lords, I was at pains to point out, my lords, the schedule. You can acquire assets, or rather, these are the assets that for which the loan has been sanctioned or financed under this agreement. This is a schedule to the 2018 agreement. You can only sanction this or purchase of A, B, C, D, provided you have disbursed. And please see, my lords, the document per se, my lords, as the my lords, they say, probably the proof of the pudding is in the eating. Please see, my lords, page the agreement. the agreement which starts at page 49, this is not, my lords, as is apparent, a restructuring agreement.
No, that is a subject matter of evidence.
Correct. No, I therefore, my lords, I understand, therefore, but that's not really, my lords, what really appears to be that this is an attempt to really cover up. This is apparently a false statement made, which is which now is sought to be, my lords, ameliorated over. But what is important is, if there is no disbursement under this agreement, there is no way the schedule could mention something under this agreement, or the assets that were financed, which they initially said was financed under this agreement, now which they seek to change and say that no, sorry, it was under an earlier agreement.
Now they want to delete paragraphs 5 to 8.
8, correct.
5 to 8, all right. Sorry, Mr. Kamat, you have not made out a case of under section 340. I'll give my reasons.
My lord, please, my lord.
But excellent argument. I was almost convinced, but borderline case.
No, I appreciate it. But just one aspect, my lord, would my
yes, please. Since I'm against you, you can definitely put. Yes.
And I would leave it at that, my lords. Yes. I must only say that if my lords could observe that the observations of rejection of this should not, my lords.
Oh, absolutely, definitely.
Those were my submission. I am extremely obliged for my enduring.
One thing, Mr.
No, nothing, Mr.
One
Majam,
thing, this is important because, my lord, this 340 is filed when the arbitrator has reserved the orders for amendment.
Maybe.
So, my lord, this should not have any bearing on the amendment, my lord. The order of
it will have a bearing on nothing. I'll make it clear.
My lord, make it.
That is a common prayer.
Yes, because this is filed after the amendment was heard and.
If it has a bearing, it will have against him.
No,
if at all, it cannot have any bearing, of course. No.
Just, my lords, so that, my lords, for the benefit of my friend, Mr. Banerjee, I must only say that on the timelines, this was filed not after it was reserved.
No, I'm not going to that even.
It was gone. It is coming up for the second time. Before
the present application has been filed under section 340 of the Code of Criminal Procedure, 1973. Full stop. Next para. Learned counsel appearing for the petitioner submits that the respondents herein, who are applicants in an application under section 11, who were in a singular, who was an applicant in an application under section 14, read with section 11 within bracket 6 of the Arbitration and Conciliation Act, 1996, had premised its case on a purported loan cum hypothecation agreement dated June 30, 2018. In particular, in paragraph numbers 5 to 8 of the said application, it was categorically asserted by the applicant therein that in terms of the said purported loan cum hypothecation agreement, 22 monthly installments had been paid. Next para. On the basis of such averments, a coordinate bench of this court had referred the matter to arbitration by appointing a learned arbitrator. Next para. Thereafter, the respondent herein stuck to its statements made in paragraphs 5 to 8 of the application under section 14, read with section 11 within bracket 6 of the 1996 Act in its initial statement of claims before the arbitrator. Next para. However, subsequently the present respondent did a volte-face, VOLTE, space, FACE, italics, and made a paradigm shift in its arguments by seeking an amendment which hits at the root of the case all along made out by the present respondent. The present respondent, in its amendment application, has sought to delete paragraph numbers 5 to 8, which corresponds with the self-same paragraphs in the application under section 14, read with section 11 within bracket 6, and sought to introduce a completely new case, which is mutually exclusive with their original case. In the amended statement of claim, comma, the respondents introduced a purported a case, purported, a case of there being previous purported agreements during the years 2011 and 2012. Full stop. The present respondent stroke claimant now seeks to portray that the agreement of 2018 was merely a restructuring agreement in terms of the previous agreements. Full stop. More importantly, comma, the claimant stated categorically in the amendment application that there was no disbursement of any funds in under the agreement dated June 30, 2018, comma, which is diametrically opposite to their original case. Full stop. Next para. It is further pointed out by learned counsel for the petitioner that the incriminating paragraphs in the application under section 14 read with section 11 within bracket 6 were affirmed on oath and were stated in the affidavit supporting the said application to be true to the knowledge of the person who swore the affidavit, SWORE, swore the affidavit on behalf of the claimant company. Full stop. It is argued that the said person who affirmed the affidavit was an employee of the claimant stroke company and could not be seen to be a naive person having no knowledge of the facts of the case. Full stop. Next para. Thus, comma, it is argued that such attempt on the part of the ওরম তাকাচ্ছ কেন? এটুকুনি লিখে হাত পাতা করছে? চাকরি নিয়েছো কেন? It is argued that such attempt on the part of the claimant tantamounts palpably to perjury and a deliberate attempt to mislead the court into passing the order under section 11 of the 1996 Act, and an inquiry should be initiated under section 340 of the Code of Criminal Procedure. Full stop. Next para. Upon a careful consideration of the arguments of the petitioner, comma, this court is convinced that at this juncture, comma, there is no mandate to give an audience to the respondent stroke accused. Full stop. Next para. The paragraphs in question of the application under section 14, comma, read with section 11 within bracket 6 of the 1996 Act are set out below. Colon দিয়ে page 38 থেকে page 40 এই অ্যাপ্লিকেশনে page 38 থেকে page 40 প্যারা 5, 6, 7, 8 পুরোটা সেট আউট হবে। নেক্সট প্যারা আইটালিক্সে হবে। নেক্সট প্যারা, such paragraphs are now being sought to be deleted by way of amendment, and the following paragraph introduced, colon, page 207, একটাই প্যারাগ্রাফ আছে, প্যারা 20, ওটা সেট আউট হবে। নেক্সট প্যারা, a careful perusal of the proposed amendment shows that the accused claimant does not seek to efface, EFFACE, or obliterate the purported agreement, the existence of the purported agreement dated June 30, 2018. Full stop. What the amendment proposes to do is to change the very complexion and character of the said document by pleading that the said document was in effect an agreement to restructure the liabilities arising out of certain previous agreements. Full stop. Next para, such case, comma, it may be noted, comma, is not entirely inconsistent or mutually exclusive to the original case made out by the petitioner, by the claimant. Full stop. What has been attempted to be done now is to relate the purported agreement of 2018 to previous liabilities in terms of prior agreements, comma, which were neither asserted nor denied in the original pleadings. Full stop. Next para. Still, the case of the petition, the claimant is that the payments, that 22 monthly installments were paid in terms of the 2018 agreement, which, however, have now been termed to be in terms of the within double inverted repayment schedule, double inverted clause. Push up next para. Hence, comma, I find that nothing hinged on the said alteration now sought to be made in the pleadings, comma, either before the arbitrator or before this court on the previous occasion, comma, which would have affected the decision appointing an arbitrator which was passed by this court. Pushed up next para. Even if the present pleadings were there on record at that relevant juncture, comma, in the opinion of this court, comma, the same would not have materially altered the premise of the order appointing an arbitrator under Section 11 of the 1996 Act. Pushed up next para. As such, comma, I do not find a high case having been made out by the present petitioner that it is expedient in the interest of justice to direct an inquiry to be undertaken on the allegations made out in the present application for perjury. Push up next para. In such view of the matter, comma, SCO 1 of 2024 is dismissed. Push up next para. It is, comma, however, made clear that the entire observations made above are tentative in nature, comma, arrived at only for the purpose of adjudicating the present application under Section 340 of the Code of Criminal Procedure, and do not, comma, in any manner, comma, purport to deal with the merits of the claim and counterclaim, like allegations and counter allegations made by the parties against each other before the arbitral tribunal or before any other forum. Full stop. The arbitral tribunal shall decide all issues before it independently without being swayed, SWAYED, in any manner by any of the observations made herein above. Thank you.
Grateful. We are extremely obliged.
Thank you.
Item number 4.
But I'm hearing my lord for the petitioner.
Yes, Mr.
My lord, it's a petition, my lord, under Section 9. My lord, tell my lord what's happened. My lord,
should I release the other matters?
No, my lord.
Yes.
This matter, my lord, at least for the time being, my lord, won't have to do that. My lord. Perhaps, my lord, I can, my lord, try and see, my lord, if I can persuade my learned friend, my lord, to accept something, my lord, which I would propose, my lord, within 2-3 minutes. My lord, I'll tell my lord what's happened. My lord, there are 3 petitioners here. My lord, we, my lord, invested, my lord, in this own your wagon scheme, my lord, with the railways. My lord, by which, my lord, we put in money, my lord, for the wagons, and then, my lord, the wagons are used, my lord, by the railways. My lord, in this case, my lord, we had done that. But, my lord, there was some dispute with the railways where, my lord, they were properly used or not used, all that happened. My lord, there are some claims which, my lord, we made against railways. And, my lord, because we, my lord, because of COVID and all that, my lord, we
you
got
get to use the wagons for your purpose.
For my purpose, as well as their purpose.
Like, give me an example of the.
My lord, I invest in the wagons.
Achha.
Then, my lord, the wagons, my lord, I pull in the common pool, and then I give an indent. So I get a priority. Otherwise, the wagons are used by the railways as well, and I get money from that. So it's basically, my lord, having your property and, my lord, also earning, my lord, by way of my lord, giving it out as well.
Right.
So that's how, my lord, the own your wagon scheme, my lord, works. My lord, I got into some financial difficulty. That's why, my lord, I had, my lord, with the respondent one, entered into, my lord, agreements for the purpose of, my lord, securing on the basis of the security of the wagons, my lord, I had, my lord, taken money. Then, my lord, we entered into a settlement agreement by which, my lord, I said I'll pay off and you release my charge. That is the agreement, my lord, which, my lord, we are concerned with 29th September 2017, which has an arbitration clause. Now, my lord, I was also, my lord, unable to pay that, my lord, amount which was fixed, my lord, between us, my lord, 23.50 crores. Then, my lord, I wanted to negotiate with them and, my lord, have it really reduced, my lord, whatever, my lord, was feasible, my lord, to pay. That's, my lord, one aspect. Now, what's happened, my lord, by reason of, my lord, my disputes, my lord, with the railways, my lord, I have got awards, interim awards, my lord, against the railways. And I have also, my lord, filed writ petition where, my lord, by reason of orders of court, my lord, money has been now, my lord, deposited in my account, rather for me, in court. Both, my lord, in the High Court here, as well as, my lord, in the Delhi High Court. Now, when I wanted release of that money, quite naturally, my lord, he came and objected and said, sorry, you can't have it released. So, my lord, I filed, my lord, this petition, my lord, under Section 9, try and, my lord, now restrain him, my lord, really claiming that money. But I know, my lord, it's not possible, my lord, unless, my lord, I really, my lord, deal with his claim. Now, my lord, I have made an offer to him. He's also, my lord, made a counter offer to me, which is, my lord, at pages, my lord, 8.
What is the relief you have seen? It's not in the Section 9 application.
Section 9, my lord, for him not to, my lord, interfere, my lord, with, my lord, this, my lord, question of, my lord, me receiving money. And, my lord, also, my lord, for receivers, my lord, to really go and, my lord,
That
collect the
is
money
really
from
an
there.
anti-suit sort of injunction. I mean,
My lord,
he cannot make an application.
that's what I've claimed. But, my lord, I just wanted to, my lord, try and, my lord, resolve this issue.
Yes.
My lord, I want to sit, my lord, kindly, my lord, adjourn this matter. My lord, I want to, my lord, sit, my lord, with him because, my lord, pursuant to, my lord, his letters. So then, my lord, something is worked out. Then, my lord, we don't have to go to arbitration. We don't have to, my lord, also, my lord, pursue, my lord, by Section 9. This was, my lord, the boy. My lord, I realized, my lord,
My
we
officer
can't.
has taken a cue. So when should I keep it, Mr.
I have a much larger claim that my learned friend says, and I also have a charge on the wagons.
Oh.
But, my lord, if we can settle the matter out of
That's,
court,
my lord, what I want to do. Otherwise, my lord, I know perhaps, my lord, trying to, my lord, not, my lord, really look after him, my lord, may not, my lord, help, my lord, my cause.
So what will be a reasonable timeline for that? I mean, for you to explore the...
My lord, next week, my lord, I understand, my lord.
Next week?
Next week. Well,
I'll keep it then next Wednesday.
next Wednesday.
Wednesday.
That's the 10th of, my lord.
10th.
Yes.
Learned senior counsel appearing for the petitioner submits that attempts are being undertaken to resolve the issue amicably between the parties. Full stop. To explore such option of mutual settlement, comma, let the matter stand adjourned till July 10, 2024, when it will be listed under the same heading.
Grateful. I'm grateful, my lord. That's why, my lord, I didn't let my lord release all the matters.
Yes.
Grateful.
Yes, for settlement.
I'm the
You,
three
you
and
two
four.
are appearing for different parties.
Yes, I'm 3 and 4. She's 1 and 2.
Who is for the petitioner? Settlement cannot be between yourselves. Arrived. Settlement has arrived.
Your Lordship, appear on behalf of the award holder.
First get settled. Yes. Then settle the matter.
Lordship, in this matter, there was a proposal that they would be settling the matter. There has been no proposal of settlement coming from them. They have filed their affidavit of assets. Let them come for examination.
We say, my lord, we are ready to pay the settled amount. We have discussed with Kotak Mahindra. We have received a mail.
You have discussed with?
The bank, to the concerned bank. The concerned bank has told us, my lord, we have agreed to give 12 lakhs subject to some conditions of payment.
Lordship, that
We
has
cannot
been
even pay
rejected.
12 lakhs with them.
That has been rejected.
Now that, my lord,
By whom?
By the bank, that has been rejected. No counter offer. 12 lakh.
Oh, you are the bank.
Yes.
The bank says it has been rejected. What remains?
So I have been told that
So your affidavits of assets have been filed.
Has been filed.
So I'll keep it tomorrow for
Yes.
judgment examination.
They are from Lucknow, my lord. Kindly,
Lucknow, then very well. I'll keep it Thursday week.
can he go for settlements for once, my lord?
Bank is there saying they're
Lordship,
not.
if they want to settle
cannot
the
compel
matter,
them.
let them give on writing what they with what amount they want to settle.
Settlement will be facilitated.
We can give that.
And let them appear on the returnable date. If it is agreed,
Settlement will be facilitated if your officer comes from Lucknow. That is what she means.
Okay, Milord. Kindly keep some time, Milord.
Some time for what? The
Because-
okay you are submitting and the okay she is submitting are different okays.
No, Milord. We will ask the client to be here. She's asking
For
a written-
examination of
No,
that.
Milord, she's asking that.
for examination.
She is asking for written.
I know what she's asking. Let him come for. They are refusing settlement.
No,
If you have anything in the meantime, we
give
can always.
something in written that we are agreeing.
No, you cannot stall the proceeding indefinitely. No, sorry. They're not agreeing. Learned counsel for the petitioner bank submits that that there has been no clear-cut offer from the on the part of the award debtor, and as such, the attempts at settlement have failed. Full stop. Next para. Learned counsel for the award debtor seeks further time to explore the avenues of settlement. Full stop. However, comma, learned counsel appearing for the award holder insists that the matter be placed in the list for examination of the award debtor. Full stop. Next para. Since the petitioner bank itself takes a categorical stand that there has not yet been any settlement, comma, no useful purpose would be served in protracting the execution proceeding. Full stop. Accordingly, comma, the award debtors, all the award debtors shall remain personally present.
What data number 1 is about the proprietorship form.
So what? No, what is, let us see.
It's judgment.
1 is the proprietor, 2 is the proprietor, 3 and 4 is the son and the wife.
Oh, 1 is the firm, obviously. And 1 is a lady, 3 is a lady. So she cannot come.
Lordship, she can come without arrest. She can come.
No, if I say, Milord, let the
Let
proprietor.
Yes, I cannot direct her.
And
No, let the direction be there. Let her come. If she does not come, maybe we cannot issue a warrant of arrest. You're right. Directing bola, there were direct. The award debtor numbers 2, 3, and 4 shall remain personally present in court on July 11, 2024 at 2 p.m. for being examined by the award debtor. Full stop. The matter shall next be returnable on the said date. Yes. Thank you.
Item number 89 of monthly list.
My lord, appear on behalf of the award holder. My lord, a date needs to be fixed for examination of the judgment data.
Settlement has failed.
But we have not received any proposal.
This is fixed for settlement. Must have been some reason.
We have not received any proposal, so.
Very well. Learned counsel.
And my lord, a leave may be given to file the supplementary affidavit because we want to bring on some subsequent record.
No, affidavit of asset has been filed by them.
Yes, ma'am.
If you want to use a supplementary affidavit, you have to give a copy to them first. Supplementary affidavit in connection with your execution application. No, then first I cannot fix a date. First file that, give an advance copy to them. I'll fix another date.
Okay.
I mean, unless the copy of that is given to them, why should? Learned counsel for the award holder appears and submits that no proposal for settlement has been given by the award debtor. Full stop. None appears for the award debtor to represent their case. Full stop. Next para. As such, comma, apparently there is no scope of settlement between the parties. Full stop. Learned counsel for the award holder seeks liberty to file a supplemented affidavit to bring in certain additional facts. Full stop. Such leave is granted. Full stop. The award debtor stroke petitioner shall file a supplemented affidavit to the enforcement application within a week from date,
2 weeks. Maybe.
within a fortnight from date, and serve an advance copy of the same on the award debtors. Full stop. The award holder shall file an affidavit of service to that effect on the next returnable date. Full stop. The matter shall next be listed on August 8, 2024 for passing further orders. To give you time to serve.
New motions. Item number 90.
কি petition এটা? New motion. 11, section 11. Not today, just not today. কোনো order করতে হবে না।
Item number 91.
Same.
Item number 92.
My application for section 11 for appointment of the arbitrator.
You have given a notice to the other side?
Yes, my lord.
Have you got an affidavit?
So, affidavits have been completed in the matter. my lord.
Affidavit is or affidavits have been completed? Yes, give the file.
Affidavit have been-
File নেই? এক্ষুনি ডেকে পাঠান বড়বাবুকে। কমিটির লোককে
Item number 93.
ফাইল আছে? ফাইল আছে কিনা আগে বলুন। আছে? দিন।
Application.
My lord, I appear for the respondent, my lord, union of.
Affidavits have been exchanged?
My lord,
No.
no
My
affidavit.
lord,
My
I
lord,
may
this is
not,
being
my
moved
lord,
for the
I'm,
first time.
I will not prefer an affidavit in a section 11, my lord. I'm only saying, my lord, I've been briefed, my lord, a day before yesterday. Kindly keeps it on a day. I'll come back. I may concede even because I don't find, my lord,
I
the
indicate, my lord, that is because
application.
this is really the second round of litigation. We had
No,
filed
need not indicate anything, Mr. Banerjee is asking for.
Otherwise, I would have asked for an affidavit. My lord, I don't believe in affidavit, my lord,
No,
in
no,
section 11.
absolutely. That is, I mean, very appreciated. I'll keep it on next Monday.
Yes, yes.
Very well. Learned counsel for the respondent seeks some time to take instructions in the matter. Full stop. Accordingly, let the matter stand over till April 8, 2024.
Much very grateful.
Thank
Thank
you. 8th April আসবে লিস্টে, হ্যাঁ? 8th April.
8 July.
July. Read my April says July. I mean, listen to my April says July.
Item number 94.
Not today. Not today. যেগুলো থাকবে সেগুলো ফাইল থাকবে না, যেগুলো নেই
95.
For the petitioner, my lord. This is my application for section 11 for appointment of arbitrator, my lord.
I am praying leave to file affidavit of opposition.
Why? What is your objection? If you unless there is a strong factual objection, I won't direct
Yes,
affidavit. I'll give my reason.
Kindly say, take it on record, my lord. I am
This is your
satisfied.
opposition.
Yes, my lord.
There was a direction for filing opposition.
Yes, yes.
Oh, acha, then file.
A copy we served to our.
I'm giving
Not
here.
given a copy. What is your opposition? What is your objection?
First of all, it is absolutely time barred.
The claim is time barred.
Claim is time barred.
It's filed in the department.
Yes.
Otherwise, it will be misplaced and
Yes,
it will
yes.
be later on.
Okay.
Very well. Then, if you're getting a copy right now, then I'll give you another week to file a reply.
Yes, my lord.
Very well. The affidavit in opposition filed to be kept on record. First of leave is granted to the respondent to file the vakalatnama of competence before the concerned department. First up, a copy thereof is handed over. You have given a copy.
Yes, my lord.
Is
I've
given to the learned advocate for the petitioners here and now. Full stop.
Yes.
The time for filing reply is extended for a week from date. Full stop. The matter shall next be listed on July 10, 2024.
Instead of 10, my lord, make it thereafter some few days.
Very well. The July 15th? 15th July. Come back
July.
on 15th. Section 11, how long is
That's why.
15 July.
My lord,
Come back. Section 11.
immediate opposition be kept in the record.
Yes, that is the first line of my order. Next.
Yes. Obliged to lord.
Thank you.
Obliged.
Item number 96.
Highlights. Not today. Not today. Not today.
7.
Not today. Not today.
Item number 98.
Same. Not today.
Item number 99.
No paper.
I'm applying for the respondent, my lord.
No use in the documents are not, the file is not here, so I cannot even record in the order. Sorry.
Item number 100.
Yes, what is the matter?
My lord, if it can be taken tomorrow, that would be better. And final, I'll prepare that notes of argument also. Along
Did
with
not
the,
prepare, no, this is section 11.
no, my lord, 34, my lord.
34.
But departmental arbitrator, one claim has been awarded in favor of me.
Departmental arbitrator, isn't he barred by ineligible?
No,
That is
long ago, 2015.
At that
That
time
is
it was not
pending
in
for
law.
this. For this reason,
My lord, it can be taken tomorrow.
Can you be prepared tomorrow or
Yes,
you
my
would
lord.
like
I'm ready for this.
I'll get it ready and I give out the notes of argument also along with the citations also.
well, on the prayer of the petitioner, ওখানে বসে লিখে নিতে হবে, এক line. On the prayer of the petitioner, the matter is adjourned for the day. First up, learned counsel are requested to prepare the written notes, short written notes of arguments and file the same when the matter is next taken up for hearing.
Well, may I file it today itself?
No, file it tomorrow.
Ready?
File it tomorrow.
Tomorrow in a supplementary list.
No, it will remain in the supplementary list. Yes.
Oh, much obliged.
Tomorrow means supplementary list.
Yes,
It has to be in the supplementary.
I'll file it tomorrow itself. It's not so.
Tomorrow, if I can take up, I mean, I don't know whether I'll be able to take up because tomorrow is the examination of judgment data day.
May I suggest you keep it on Monday in a supplementary list so that matter can be hard out.
Very well. তাহলে বাবু একটুখানি অ্যাড করো till তাহলে July 5th, July 8, 2024, huh?
But also record that I will both the parties will file written notes of argument.
That I have stated. Whatever everything else I have stated, only the date it becomes July 8. Next month.
Item number 97, my lord.
Item number 101.
Yes.
My lord, in this matter, my lord, I appear for the petitioner, my lord. This is an application under section 34. My lord, there was a direction of filing of affidavit, my lord. No affidavit has been filed by the,
If they don't file an affidavit, we'll proceed to ex parte.
my lord. Kindly adjourn it for 7 days, my lord. In the meantime, I will issue a letter to them asking whether they.
Very well. None appears for the respondent at the time of call. Stop. Learned counsel for the petitioner submits that no affidavit in opposition has been filed by the respondents as per previous direction of court. Full stop. Next para. As a last chance to the respondent to appear and contest the matter, comma, the same is adjourned till July 10, 2024. Full stop. The learned advocate on record for the petitioner is requested to give a notice in writing to his counterpart, his or her, your advocate on record? His counterpart appearing for the respondent, indicating the next returnable date and file a receipt to that effect on the next date of hearing. I'll take up ex parte if they don't come or give a notice, ensure that.
Item number 102.
Yes.
Lordship, I beg to appear on behalf of the
Yes,
petition,
please.
Lord.
Yes.
As per the last direction of my lord, we have served, but the notice has returned back, my lord. This is my affidavit.
You are appearing for the respondent.
Yes, my lord, I'm appealing.
Lordship. Then
let us hear the matter. Section 34.
Lord, this is the first time we are appearing, so my lord, I need direction for
Affidavit. How long? 1 week, 2 weeks?
2 weeks.
On the prayer of the respondents, the time on the prayer of the respondents, comma, the respondents are
But
directed.
however, my lord, one of my major grounds are that, my lord, the jurisdiction invoked is also incorrect because I have filed an execution case which is pending on the original side.
I'll keep that
commercial
open.
notice.
I'll keep that open. Put it in your. I'll take it lock, stock, barrel and decide it. Maintainability point as well as everything.
That is because, my lord, in case they seek to argue, my lord, I have my execution case in which possibly they may file an application for stay of the execution. So if
They may. They may.
yes, my lord.
as of now,
Absolutely
They also take the point. Same point.
I have no objection, my lord, I can go ahead with it. But, my lord, subsequently they would only suffer because once my execution is
Let
in
them suffer. They are here to suffer.
as of
Either in my hands or in your client's hands.
Lordship, as
There is
of
this an
now,
option.
we are
It's
unaware of any execution proceeding, Lordship. As of now.
because we filed it
As of
within
now.
2 years, so I'm not supposed to serve it, my lord, unless the court directs.
File their affidavit. দাঁড়ান respondents না করে একজন
Lord, sole respondent.
the respondent is directed to file its affidavit in opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The matter shall be listed for hearing on July 29, 2024.
Lordship, kindly make it 2 weeks, Lordship, because
2 weeks, acha, very well. তাহলে
for us, kindly.
affidavit in reply within 1 week না করে within a fortnight thereafter, full stop. The matter shall be listed for hearing on August 7, 2024.
Grateful.
Lord, may I only make one indulgence, Lord, except 7, 8, 9th, my lord, any other day would be convenient, Lord. Except
Very well.
7, 8, and
August 12th.
Grateful.
August 12th. You are taking a point of jurisdiction also.
yes, my lord.
It is made clear that all issues, comma, including the question of maintainability stroke jurisdiction, are kept open for being decided at the final hearing of the matter.
Grateful, Lordship. I will answer on.
Next.
Item number 103.
Yes. Not today. লিখতে হবে না।
Item number 104.
Same.
Item number 105.
Lordship, item number 105, Lordship, I beg to appear on behalf of the respondent applicant, Lordship.
Not today has been
Lordship.
granted on the prayer of the petition.
Lordship, Lordship, my opposition may be filed, Lordship, kindly, Lordship.
This is in which matter?
105. Lord, 105, Lordship.
That's why you are appearing. They're filing an opposition. She's trying to file from eternity.
Lordship, we have already served, Lordship. Lordship, and 18th
I'm
of
satisfied
April.
that it should be taken on record.
Grateful,
So
Lordship.
reply, you are prepared with your reply. Use the mic, use the mic.
We've been served, my lord, 2 days back. My lord, if I could
2
be
days back.
granted a
Well, I'll give you 1 week. 1 week.
my lord, I'll come back.
The affidavit in opposition filed today be kept on record. Full stop. On the prayer of the petitioner, comma, the time for filing reply is extended for a week from date. Matter shall be listed for hearing on July 15, 2024.
If I may interject, my lord, also that there was a stay of the arbitral proceedings, my lord. That was that is expired on 30th of June, my lord.
Lordship, I am objecting to it.
Limited stay could be granted.
No, I'll extend the stay for the push up. Learned counsel for the learned counsel for the petitioner also pays for an extension of the interim order of stay, which has since expired on June 30th, 2024. Push up. Next para. Learned counsel for the respondents vehemently opposes such prayer. Full stop. Next para, however, comma, I do not find any change of circumstance to vary the stand of court and effectively vacate the said order of stay by refusing to extend the same. Full stop. Accordingly, the interim order of stay granted earlier is extended stroke reimposed as on today till July 30, till August 2024 or until further order, whichever is
Lordship,
earlier.
may I be permitted to submit one thing only, Lordship? Lordship, their statement of reply date was 18th of April, Lordship, last day. After that, they have filed this application. Lordship, kindly consider only this much I have submitted.
Everything when I take up the matter for hearing, ma'am. Yes, next.
Lordship.
Item number 106.
Lordship, this is my section 34 application, your lordship. On the last occasion, there was a direction to file affidavits, your lordship. Nothing has been filed.
Give a notice to them. Section 34, I won't take up expertise. Give a notice.
All right.
I'll record whatever you said. None appears for the respondent. Full stop. Learned counsel for the appellants submits that no affidavits have been filed as yet in terms of the direction, in terms of the previous direction of court. Full stop. Next para. As a last chance to the respondents to appear and contest the matter, comma, the same is postponed till July 10, 2024. Full stop. The learned advocate on record for the petitioners is requested to give a notice to he's the advocate on record to his counterpart appearing for the respondent, indicating that the matter shall indicating the next returnable date and file a receipt in that regard on the next date of hearing. Give a notice, Mr. Mondal, and file a receipt on the next date. I'll take up expert if they don't appear.
Did that.
बोलम जो 10th July 10th.
New motion. Section 37. Item number 107.
Your lordship, this is my section 37 application from an ex parte order dated 16 for January 2024, your lordship.
What is the nature of the order?
Your lordship, if your lordship comes to page 20, respondents are directed to pay a sum of 1 crore 35 lakh and odd.
This is appearing for the first time.
No, your lordship.
I've given a notice.
For the second time, affidavit of service is filed, your lordship, already.
No, affidavits are directed as it.
No, your lordship.
Achha, what is your case? Make out your case now.
Your lordship, ex parte order has been filed, has been passed, your lordship. We have not received any section 21 notice. No notice under section 12 also has been received, your lordship. Completely unilateral proceedings has been started against us, and thereafter this notice, this
The
order has
statement
been
of claim you have not got.
Nothing, your lordship.
You have averred that in your which paragraph of this? I mean, in your application, where have you averred that? Show me that statement in your GA.
Your lordship, paragraph 9, page 5. Your lordship, due to the COVID, during the COVID period, he could not pay. There, he had intimated this to the respondents herein.
The paragraph 9 says something else. You have not stated that you have not got any notice.
Thereafter,
Paragraph
10 says that we have filed a suit, your lordship, after we have come to know that of this.
You owe them money.
Yes, your lordship. It's a loan agreement.
Loan.
Yes, your lordship.
So then what happened?
Then we have been paying the loan, and thereafter the COVID, the pandemic hit, your lordship. And
Yes.
during that period of time, we could not pay certain installments.
Hmm.
And during that time, we had intimated them. They had agreed that no action will be taken against you. And thereafter, they have we have been served paragraph 11, your lordship. We have been served with this order. Coming to know of this order, we have filed an suit in the City Civil Court.
Suit
Yes, your lordship.
is a suit. I mean, coming to know of the order, you have to appear before the arbitrator and make out your case.
Yes, so after that, from that order, your lordship, we
Yes.
have filed the section 37 application.
How can you file a suit now deliberately? There was an arbitration clause in your agreement.
The agreement is never served to us. Agreement was never given
But
to
you have
us.
to secure the amount. I appreciate you have got a good case in your section 37 in
Your
the sense that
lordship, 37
finally leave probably has been granted. But you have to furnish a bank guarantee or
Your
something.
lordship, section 17 cannot be passed ex parte, your lordship.
Show me that from the statute. That no interim order can be passed ex parte.
Your lordship, section 17(1) clause 2 states where the interim order can be passed.
Yes, like an order 39 case.
Yes, your lordship. But these there
Where is it stated that no ex parte order can? That is there even in order 39. That without reasons you cannot pass an ex parte
ex
order.
parte order,
It
your
is
lordship.
absent in section 17.
No, it is not there in section 17.
So
it's
by
section
specific
17.
exclusion, intention of legislature is very clear. It can be passed. That fetter is also not there without any reason. That is why I asked you. Order
Section
39
39
puts in a
says-
yes.
yes,
Order 39 puts in a fetter
Yes, your
that you can't pass ex parte orders. You can, but without with reasons. Here that is also not there.
But your lordship, no notice
Section
was
17
given to us, your lordship, completely
You have to
unilateral
secure this
appointment, your
amount,
lordship.
ma'am. You have to secure. Your client has to secure this amount. Put in a bank guarantee. I'll grant a stay.
Lordship, let me come up with the instruction, your lordship, on the next day.
No, I'll pass an order.
Lordship
That will be
gives me-
conditional.
Gives me
No, after
1 or
hearing, I
2
won't grant you time. Ad interim, the ad interim, either I'll refuse or I'll put in that order.
Lordship, let me come tomorrow. The lordship keeps it tomorrow, your lordship.
Come back tomorrow. On the prayer of the petitioner, the matter is adjourned for the day.
Grateful, your lordship.
New motion, section 15, item number 108.
And I am for the respondent, my lord.
Both of you are ready?
But I'm late by Mr.
But I think I'll be conceding
He'll be considering. Very good, very good.
because, my lord, it's a section 14 read with 11, my lord.
Acha.
Now, the arbitrator had long ago, my lord, had heard out the matter and thereafter has not published his award.
Ah.
Now, my lord, it would need a fresh hearing because it cannot be that the learned arbitrator can remember all these things. It will be very difficult. My lord, also, we have Supreme Court judgment that says that if you do not pass a judgment within a specific period of time, it is unnatural for the person to remember, my lord.
No, I
So, my lord,
understand that,
I think, I don't know
Mr.
what Mr. Bose is.
What do you say?
Mr. Roy has moved my application.
Yes, right. Yes.
My lord, admittedly, my lord, hearing before the arbitrator concluded in February 2018.
Why did you wait for so long, Mr. Bose? Why did you wait for so long?
There has been innumerable letters which has been written, which is on record to the arbitrator.
6 years.
And my lord, I think that is after completion of arguments, my lord.
Yes, yes. Mane, after by a minutes it was recorded that the arbitration hereby stands concluded, reserved for passing award. Yes, my lord, in fact, the matter was taken up. My lord, now what we can say is that, my lord, it can.
So then you have paid for appointment of a new arbitrator.
Of course, we have. My lord, this under 14, the mandate stands terminated, and under 15,
Yes.
the arbitrator has to be substituted.
Substituted.
If your lordship kindly take 14.
Yes.
Fourteen 1A is the situation here.
Hmm.
He becomes de jure or de facto unable to perform his functions, or for other reasons fails to act without undue.
There is de facto unable to perform. It will be.
Absolutely. This is reason. And then, my lord, if your lordship will see, if in a situation of this nature, subsection 15, subsection 2 will apply.
2, right.
Where the mandate of an arbitrator terminates, a substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator being replaced. Now, on the appointment procedures, I have an issue, my lord. The appointment procedure prescribed that the respondent would appoint an arbitrator. There, my lord, the judgments of the Supreme Court in the case of Perkins, TRF, they come in. So, my lord, since they have interest in the subject matter of arbitration, they cannot be an appointing authority. So, it has to be appointed by an order of court.
That becomes a problem. My lord. But
What?
the only problem, again, there is a legal problem. And I was very candid when I was just thinking on those terms, my lord. My lord, if your lordship has to go back to section 11, my lord, then my lord, section 11 has in itself, my lord, a limitation period.
Yes.
So, my lord, that might become a problem.
By 11, 15,
15 would relate back to 11, my lord. So, my lord, that 6
Under
years, my
15
lord,
to Mr. Rai, do you say that under 15 to independently the court cannot appoint without relating
it
back?
is the rules. The rules have to be followed. And your lordship will appoint under
If the
the
rules are
same
not
rules.
followed, then we go back to section 11, 5 and 6 and all this.
Yes, because my lord, now today the rules cannot be followed because unilateral. So he has to take out a section 11 then.
Mm-hmm.
My lord, may I just come back on this, my lord? Your lordship, my lord, today we have a 3:30. If your lordship can, because may I just come back on this point of law, my lord, because it struck me. Therefore, my lord, the appointment, I don't know whether I'll be.
Apparently, Mr. Rai, you are right. Unless because if the rules are changed, there is no provision for that in section 15.
No, that is not there, man.
Mr. Bose, you also please consider
Yes,
this
yes,
issue
yes,
and
I-
come back.
Yes.
When should I keep it? Tell me, both of you.
My lord, next week, my lord, kindly.
I'll keep
Anytime
it
next.
next
Well-
month. I'm keeping it whenever it is taken up.
Yes, my lord. Very grateful, my lord. Very grateful.
And it just check up.
Very
your-
good. Very
Yes.
8. Monday would be 8. Yes, very well.
My lord, may I kindly take your lordship's leave, my lord?
Yes, absolutely.
And I've been summoned by a court, my lord. I'm grateful.
The present application is under sections 14 and 15 of the Arbitration and Conciliation Act 1996 has been filed in view of the learned arbitrator who was previously appointed, having concluded hearing in the year 2018, but till date having not passed the award. Full stop. Next para. Learned senior counsel appearing for the petitioner submits that the situation comes within the purview of section 14 within bracket 1 within bracket small a, comma, read with section 15 within bracket 2 of the 1996 Act, comma, since by his conduct, comma, the learned arbitrator can be deemed to become de facto unable to perform his functions and having failed to act without undue delay. Full stop. Next para. However, comma, and although the respondent does not have any objection in principle to the arbitrator being substituted, comma, learned counsel appearing for the respondent raises an interesting question as to whether, comma, since the petitioner is not agreeable to abide by the rules that were applicable to the appointment of arbitrator, comma, in respect of the said substitution, comma, the provisions of section 15 can suffice independently, comma, without relating back to section 11 of the 1996 Act, comma, which provides for situations where if the parties cannot agree to the rules of appointment, comma, the court can independently appoint an arbitrator. Full stop. Next para. As such, the question as to whether the rigors of Section 11 would apply is required to be gone into. Full stop. Learned counsel seek an adjournment to come prepared on such issue. Full stop. Accordingly, let the matter stand adjourned till July 8th, 2024. When it will be July 8, 2024 under the appropriate heading. Thank you. আর একটা দুটো taken না?
Application.
Yes.
Item number 109.
I missed the brief. It is my substitution application. My affidavit service is kept in record. My
I require that if it is there on record.
last occasion it was taken on record. My substitution of judgment letter, sole judgment letter died. Thereby, her husband was substituted. Husband was died. After special officer was appointed.
You don't have a copy of the brief.
Yes.
Come back tomorrow.
Yes,
Come back.
yes,
Not just not today. Record করতে হবে।
Item number 110.
Lordship, I'm praying for a not today.
Item number 111.
There is a stay. There's a stay which has been granted by the appellate court. Your Lordship will be playing this matter.
What is this? This is section 34.
36, Your Lordship. Execution application, Your
Stay has
Lordship.
been already granted.
Yes,
And
Your
we
Lordship.
have met with the conditions of stay. So kindly.
So should I mean, adjourn it, sign it, or what?
I think that would be better because unless that is heard out,
Section 34 has been section 34.
37 is being heard. Has to be heard.
36.
Division means.
Yes, Your Lordship.
Is it fixed on any date?
That was supposed to appear yesterday under the heading
It's not.
short hearing. matter.
Yes, Your Lordship.
Still adjourn for. I'll keep it in the monthly list of August.
Yes.
Yes,
In the meantime, if something happens, please.
Grateful, Your
I'm
Lordship.
grateful.
Learned counsel appearing for the parties submit that a stay has been granted by the appellate bench under section 37 of the Arbitration and Conciliation Act 1996, which as such, the present execution application cannot be proceeded with. Pushed up. Accordingly, on the prayer of the parties, let the matter be adjourned and listed next in the monthly combined list of cases for the month of August 2024.